Please note that this content is for educational purposes and for adults only. Viewer discretion advised. More details available in the description box.
Hello everyone and welcome back to another live stream with me, Grizzly K. This is Grizzly True Crime and we are back to talk about the Idaho case. I know that sounds very vague and broad, but the Idaho 4, where 4 University of Idaho students were murdered in their off-campus college home in November of 2022. I can't believe it's that long ago. It feels like last year or something, right? But a lot has happened since then. Bryan Kohberger is the suspect. He is going to be on trial supposedly this year. I hope so. It seems like the judge is like, yeah, it's happening this year from August 11th until November 7th. That is a long time. Whoa, from August 11th until November 7th of 2025, there'll be 2 phases of the trial. The first will be the guilt or innocence phase, and the next phase will obviously be the punishment phase because this is a death penalty case. So Bryan Kohberger is 30 years old now, and he is facing the death penalty, which in Idaho now could be via the firing squad. So we did a live stream on this case to update ourselves on 1 million documents that were filed, and there as well I took a long time just to get that all together because there's so many, there's hundreds of pages to read, and sometimes in like a 80-page document there might be one sentence that I think you would find really interesting. The rest is kind of like, okay, it's just part of all the legal back and forth, right? So that's what I've done this time now again as well, meaning if you check out the playlist, which is linked in the description box for you, you will find the previous live stream where we looked at, Kohberger's selfie and bushy brows and what DM said and the 911 call transcripts and all of that as well. There was a lot in that video too. I'm sure there will be a lot in today's one as well. So make sure you buckled up because we might be here for just a little while. I'm doing my very best to only bring you what I think you'll find interesting. The highlights, the bullet points, the summary. Let's get to it, right? So we're going to do that. Also, I wanted to say that right after this live stream, you're going to be teleported or redirected to Courtroom Confidential because Greg Hartley from the Behavior Panel was interviewed by Josh Ritter, who is a friend of this channel. He was actually a guest on the show just a few days ago. And so I can't wait to see that interview. I'll have to catch it on the replay because it's happening at 2 o'clock in the morning for me. But for many of you, it'll be the perfect time right after this to go and check that out. There'll be a few hours in between. So I hope you will check that out and like and share and all of that. Perry, thank you so much. Welcome everyone. Now, I've made a little summary of what we're going to go over today. So motions on evidence admissibility. The defense's push to strike the death penalty. Autism spectrum disorder as a defense factor. The prosecution's evidence on Kohberger's purchases. We've already gone over some of that in the previous live stream about this where I summarized a whole bunch of documents. We went over his K-bar knife purchase as well as searching for a replacement after the murders had taken place. So there's that as well. Debate over language in court, bushy brows, the use of the word murder, things like that. The prosecution's response to a whole lot of the defense's motions, discovery violation allegations, mental health and execution concerns, as well as trial logistics and public sentiment. So just to, can you guys hear me? Judy says, volume drop. You can hear me, right? I'm just checking. Please like and share. So basically, if I just quickly count here, there's 7 defense motions that I've picked out of many, and 5 state's motions that I've also picked. So please know, the volume dropped? I don't know. It shouldn't drop at all. I don't know why it is dropping. Listen, YouTube, don't you mess with our volume, okay? So, when I say picked, I mean I've read through all the new filings. They're all on the Idaho.gov site. It's linked in the description box as my source. And if you want like all the information, I would recommend just go reading it yourself, right? Just go read it. So somebody's going to be like, you cherry picked this. Yeah, I'm bringing you the summaries and all the latest, greatest details in this case. Okay, so one more time, recap. We're going to look at the Bushy browse, the touch DNA, the vague and undisclosed expert testimony, the Amazon click activity, the self-authentication records, the motion to strike the death penalty, and AT&T advanced timing records. And from the state, we're going to look at psychiatric and neuropsychological evidence, debates over the 3D model of the house that will be used at the trial, which kind of makes us all raise our eyebrow, at least one. Like, state, you chose to demolish the house, and now you don't have a model to scale? Okay, anyway, we'll get to it. Kohberger's family members might testify against him. We're also going to read Bryan Kohberger's crime scene essay, and then we're going to see the state's response to this advanced timing, the AT&T records, okay? Okay, so are we ready? First, I am structuring this live stream as efficiently as I possibly can. What I quickly want to run over is this, because there are a lot of new people here and they are feeling extremely overwhelmed. And so we're going to have a very quick little recap that on November 13th of 2022 at 1122 King Road in Moscow, Idaho, that's where the murders took place, right? Okay, Rob says one sus. Bushy brow. Okay, so the house at 1122 King Road is a 3-story, 6-bedroom, 3-bathroom off-campus home. It's only 3 miles from the Sigma Chi fraternity and only 0.7 miles from the University of Idaho campus. All 6 people in the home, including 1 male visitor, were studying at the University of Idaho. Okay, Trixie Red, thank you so much. So this is a presentation we'd gone over in the past. I just want to bring you some of the highlights. I've tweaked it a little bit. Now, we went over every single victim, and there's 4 victims in this case. It was a quadruple homicide. Oh my goodness. So if you want to learn all about them, you can either pause to read now, or you can just watch a previous episode where we went over everything slowly. Madison Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin, right? So those are the victims, and we learned all about them. This is what the house looked like, which is why I think it's important they get the 3D model right. They're saying it doesn't, the state says it doesn't have to be to scale. I personally disagree. Make it to scale, because it's a very strange house. You know, this would be the ground level, but if you just go around the back, there's also that sliding door at the back, and that looks like ground level, and it can be really confusing for the jury. Spell it out for the jury. They're going to need to know, right? So November 13th of 2022, between 3 and 4 a.m. is what they initially told us. But really the murders were between 4:08 a.m. and 4:20 a.m. Okay, so on the top floor was Madison Mogen's room, and Kaylee was in that room as well. So Madison and Kaylee had a room upstairs. Kaylee had already moved out, and she was actually just visiting to show off her new vehicle. She got a Range Rover, and she wanted to show Madison Mogen, her best friend, look at this car I got. Then there's the living room, and in the middle floor there was Xana's room. And her boyfriend, Ethan Chapin, was sleeping over for the night, right? And then at the bottom was Bethany's room. Sorry, the whole name is there, BF, one of the surviving roommates. And this was confusing initially because they said the 2 surviving roommates were at the bottom. But it turns out that DM's room, Dylan's room, was middle floor. That's how when the suspect walked past her, she could see him, right? And she was very scared, apparently, according to the text messages and all of that. And BF said, come, run downstairs, run here, down to me. And so she apparently did run downstairs, and the 2 of them were in Bethany's room for the rest of the night until they called 911 8 hours later, right? So this is just the layout of the house for those of you, I don't know, who haven't seen it. We don't have to go over all of this, what we don't know. We've been through this before. Some last social media posts, it's on the playlist, okay? Anything you see that you're like, no, I want to see that, it's on the playlist, okay? So really I want to go over this because it's important based on, we need to lay a foundation so that when we read the documents, it makes a little bit of sense. November 13th of 2022, at 2:44 a.m., Bryan Kohberger is alleged to have. So he's innocent until proven guilty. These are just, this is what the state is saying his movements were based on the Elantra that he was driving, based on the phone records that they have of him, okay? So they said at 2:44 a.m., he left the Steptoe Apartments and he started traveling towards Moscow, Idaho. The defense disagrees. They say they've got exculpatory evidence that he wasn't driving towards that direction. He was actually going stargazing in literally the opposite direction. Anyway, at 2:47 a.m., his phone stops reporting to the network. That's why the defense has something to work with there, because they're like, well, he didn't go that way. He went the other way. At 3:26 a.m., the Elantra was then going westbound on the 700 block of Indian Hills Road, which is all around the house. Okay, we've done map time before as well. At 4:04 a.m. was the 4th time that the vehicle entered the King Road residence, and then did a 3-point turn and went back to 112 to King Road. We're almost done with the summary. Then at 4:20 a.m. after the murders, okay, at 4:20 a.m. this white Elantra, or a white vehicle, speeds off from the house. I wonder if those surviving roommates heard that at all. At 4:48 a.m., Bryan Kohberger's phone is back on the network. He did a long drive and then went back home. He went south, west, and then north, back home to Pullman, Washington, where he was a PhD student in criminology. 5:30 a.m., he was back at his apartment, okay? So there's a few trips. If it's Bryan Kohberger, what they're saying is that he went to the 1122 King Road house. That's what the state says. They allege he committed the murders and then drove south, west, and north and went back to his apartment. That's trip 1. Now, trip 2, he travels back to King Road. I think they said the time was around there, 9:12 to 9:21 a.m. They say that he went back to the house. And we've always wondered if he did, because that's what the state alleges. Did he go back because he's like, crap, I forgot the knife sheath? Or did he go back because he expected to see, I don't know, cop cars and everything? I don't know. Okay, so he went there, and then 9:32 a.m. arrives back at his apartment. Now we know that at 10:31 a.m. he took a selfie. So that's the one we looked at before. There's the selfie. I don't know actually if that's in his apartment, but based on the phone data they have, I think so. Because that's why I wanted to look at this. Okay, so trip number 1, here we go. From the apartment, King Road residence, allegedly commits the murders, back to his apartment. Trip number 2, back to the King Road house, back to his apartment. Now trip number 3, at 12:36 p.m. he drives south towards Clarkston. The Elantra was picked up on a camera around Kate's Cup of Joe. He was at Costco's and a Walmart and Albertson's grocery store at 12:49 p.m. wearing surgical gloves. And then at 1:04 to 5:32 p.m. his phone was back on the network. So for a while there, they said, yeah, at 5:36 p.m. to 8:30 his phone stops reporting to the network. So I don't know where he went then. I have no idea. Okay, so we've gone over who's been cleared at the time. This was interesting just to look back, because this was from before they even arrested him. The longer time goes on, the more likely it is that the killer is someone not in the immediate circle of the victims. Now remember this because he writes about that in his crime scene or crime scenario essay, okay? And we had said all DNA collected would have already been tested and in the system. The toxicology reports should be available around December 25th to January 8th, may be delayed due to the holiday season. DNA testing may be tricky based on it being a college or party house, so clearing everyone would take a while. And I said, what if this is a sadistic killer, possibly a sadistic sexual predator, a fantasy killer, someone who we do not yet have a name or face for yet? Right? And we were saying it's much easier to blame the roommates, the friends, the co-workers, the people we can see in the food truck video, the neighbors, than to think this is someone who silently entered a home at night and brutally killed 4 young adults. So we were looking at all the types of knives. What could we look for in someone who could do this? Physically strong, may be prone to abuse or harm animals, may have a knife collection, may dwell on fantasies of murder or violence, very likely to have suffered severe trauma in childhood, likely a loner, may have just lost their job, college tuition, or failed. So all interesting to look back, right? Because we were speculating what this profile of this killer could be. May have recently been released from being incarcerated for violent crimes, may have had a recent loss of a significant relationship, and may literally be a serial killer. And we were saying whoever he is, whoever they are, whoever she is, whatever this is, they will eventually be caught. And they were. Now, NJ Kathy said, is there a time zone difference between Washington State and Idaho? I don't think so. From what I've checked, I don't think so. But it's easy to just double check right now. You can ask Uncle Google, and Uncle Google will tell you, right? Say the time there, say the time in Idaho, especially, what was your question? Where exactly? It was in Moscow, Idaho, right? So you'd have to check, because Idaho's got 2 time zones. You've got to check Moscow, Idaho, and Washington. I don't think so, though. Eddie, don't worry. Thank you so much. All right, so now are we ready to dive into these documents? Here we go. Let's do it as efficiently as we can. right? So there's 7, 8, 9, 10, 11, 12. 12 documents to work through. Some are just, I'm just going to bring you just 1 or 2 sentence highlights, and then after that, we're going in. So this one is when I've highlighted in this orangey red color, I don't know what you would describe that as. Alice is laughing at Uncle Google. Just ask Uncle Google, okay? The reddish shade is the defense's documents. It's documents from the defense. When it's purplish like this, then it's from the state, okay? Color coding always helps my brain. I don't know if it helps yours. But I've lined them up so that we can just go through all the defense documents first. There's 7 of them. Then we'll go through the state's ones, and it's just the ones that I have picked for you. Loki said, on this case, I can't agree. There's not a lot adding up, so I'll refrain from deciding. Well, you say I can't agree on what? Because I haven't shared my opinion at all. So thank you, Loki, for your sticker. Just know all opinions are welcome. If you're basing it on my title, is evidence stacking up? That's an open question. Tell me your thoughts, everyone. You said there's not a lot adding up, so I'll refrain from deciding. Yeah, well, let's wait for the trial, right? August 11th until November 7th. Clear your summer. Summer's been cancelled. We're doing trial. Okay, if you're in the Southern Hemisphere, winter has been cancelled, we're doing the trial, okay? Now, defendant's objection to state's motion in limine regarding self-authentication of records. So, as I said to you, I'm only going to be reading you the highlights, so let's go to it. It says, oh yeah, I just wanted to show you that it says, in support of his objection, Mr. Kohberger describes the size and complexity of each item for which the state requests admission with a promise certificate as follows. So they basically just were saying that this is, through his attorneys, hereby objects to the state's motion eliminate to admit self-authenticating records. The state provided a list containing terabytes of discovery in its motion for admission at trial based on an exception to the rule against hearsay. And so they're just saying it's really voluminous, right? Beverly, congrats on almost 2 years. Midna says he's guilty. Well, no, he isn't. He's innocent till proven guilty. But in your opinion, you think he's the guy. Okay, interesting. So here they just talked about how big these files are, the Linda Lane surveillance footage. So this is all the footage from where the state believes they captured the Elantra, right? So they're saying hard drive provided on 4/5/22 and Linda Lane surveillance footage. So basically what I want to show you is, look, they've got a lot of surveillance footage. Albertson's Clarkson, Washington video surveillance. That's from that 3rd round trip that he did, allegedly. And business records for November 13th of 2022. They've also got from Amazon financial and user records for Bryan Kohberger. Contains an Excel spreadsheet with information and categories for subscription information and order history for Amazon account, Mr. Kohberger and his family members. Now that's important because, as you can see here, the next sentence says that AV243 contains Mr. Kohberger's father account records and purchase history. These records list purchases for the entire family. And then the next one says contains subscription history, click activity, and sign-in history for the Amazon account for Mr. Kohberger and his family. That's important because the state has said that they intend to call Bryan Kohberger's family to the stand. And I think that that would be important so that the state can ask them questions about, did you buy a K-bar knife? Did you buy it? Do you share an account? Does he have his own account? Does he have an email address with his own account? How do you buy things on Amazon? Did you see this package arrive? Did you see him get a K-bar knife? Did he talk about it? What did it look like? Did he lose it? Did you see it again? There's a million questions they could ask the family, and I do think it's important to call them. I'm sure it would be very uncomfortable for them, but it's important for the case to call them, you know? So yeah, that's going to be interesting to hear all of that as well at the trial. And then here is also some news that's been going around that says Dick's Sporting Goods record of sale for Bryan Kohberger. The disclosure contains a copy of sales record from June of 2022. The state has not specified what records it intends to admit as evidence, how it was made and kept in the course of a regularly conducted business activity, and if it was regular practice of that business to make the report a record. That is the purchase of a balaclava. And it's important because while it could just be a winter ski mask, it was very cold at the time in Pennsylvania, where he stayed with his family when he bought that, which was in January of 2022, which was months before the murders, which occurred in November of 2022. it could be a normal purchase. I think the problem is when the jury hears how this one of the surviving roommates described the mask and just seeing eyebrows and eyes, and then she drew it, and then seeing that what he bought is like that, it looks just like that, because they have the receipts from what he bought, right? That's going to be interesting. So it's when you put it all together. They say the same for body language, right? The behavior panel will say you can't just look at one thing, you got to look at the whole cluster. So I feel like in this scenario, it's also like, well, no, buying a ski mask is not a big deal. But if you're buying a ski mask and a K-bar knife months before the murders, and then you're searching for a replacement knife after the murders, and then the police are apparently not finding these items, like in his parents' house or at his house, you know, then it starts getting interesting. And then he was driving a white Elantra, and then all these things. I think it can get interesting for the jury if they put that all together, but it depends also what the defense has, right? Okay, so I'm scrolling down to where I've highlighted. Here they also said Under Armour transaction records for Bryan Kohberger, and that was, they said that he made a purchase on the 24th of June of 2022. In a different document, they said they don't really intend to use that anymore at the trial. So that's interesting as well. Then Walmart surveillance and financial transaction records for Bryan Kohberger. It's always a Walmart. Sorry, Walmart. They said this disclosure contains purchase history for Mr. Kohberger. This disclosure is one of several containing surveillance videos from Walmart. In this particular folder, there are multiple cameras and surveillance videos. These would not open and were provided in a converted format, right? Remember, the defense is complaining about just how much evidence they've received, how much discovery, and that it's not categorized well, not organized. It's hard for them to navigate and to know what the hell the state's going to use this for. But yeah, they're talking about the Walmart records as well. And so let's continue on. Again, if you feel like you're missing out on any of the information I'm scrolling past, you can go read the documents in full by yourself, or maybe somebody out there on YouTube's read them all to you. I'm bringing you the highlights, all the top bullet points. Now, right now, that's news today on March 31st of 2025. Okay, now this one is also from the defense. As you can see, the color, reply to the state's response to the defendant's motion in limine, number 7, regarding witness identification by Bushy eyebrows. Now, look what the defense says. They said, mistaken identifications have been one of the leading causes of wrongful convictions in the United States for decades. Let's make it bigger for you. And still are, they say. When a witness swears under oath to the identification of the person on trial, the impact cannot be understated. In this case, if DM, one of the surviving roommates, is allowed to say that she saw bushy eyebrows, it will not be different than her pointing to Mr. Kohberger and saying, that is him. I find that statement quite interesting because I'm like, okay, so the defense admits he has bushy eyebrows. Like they're just saying it right here. Just like, if she's allowed to say the words bushy eyebrows, the defense says they might as well be pointing at Kohberger and saying, that's him. Okay, that was an interesting statement. So let's go down here. It says in the 4th interview, so DM was interviewed multiple times by the police on the day when the police arrived after the 911 call was made. The next day, we went over that in the last episode. Now they say in the 4th interview on December 1st of 2022, DM drew the mask for the interviewer. A copy of DM's drawing is attached. I'm sure you've seen this going around on the news as well. We will get to that. Okay, wait, let's get to it. There it is. There it is. So let's just turn it quickly. Okay, so what the state is saying, this is what DM drew, that only the eyes were then showing, and that what he bought at Dick's Sporting Goods looked similar to that. Now let me also just show you this quickly. I think, yeah, this one. This is something that I showed you last time that AI made. There we go. So it could be something like this, and if you just walked past her, the intruder, I mean, just seeing one eyebrow is very possible based on how the house layout is and just walking past, right? So anyway, so it would be something like this, which again wouldn't be unusual to buy in the cold, but is it unusual perhaps that DM drew it and that's the same type of mask that he bought? I think it gets interesting. Okay, now I've just got to turn this again so we can go back to where we were. Okay, so we saw that. Now, I just wanted to read this little footnote here to you because shame. You know, the defense is saying, but DM is not a reliable or credible witness because she was very drunk. She said things were very fuzzy. She can't quite remember. She's not sure if it was real or not. Well, here they clarified just how much she drank in 24 hours. They said on Saturday, November 12th of 2022, through the early morning hours of Sunday, November 13th of 2022, DM had consumed champagne, 9 to 10 seltzers, which are those white claws with 5% alcohol, Borg, a concoction of hard alcohol, water, and flavoring in a big plastic jug, and a known amount of alcohol while participating in a drinking game. Motion in limine number 9, Exhibit 6, Gooch interview transcript. Okay, this footnote just recites the alcohol consumed in an approximate 24-hour period and does not include alcohol consumed in the immediate days prior to November 12th of 2022. Now, this is, please don't shame the amount of alcohol. Don't say anything like that. It's just to look at, well, how much did she drink? If she said it was like super fuzzy, she can't quite remember, but what she remembers is those eyebrows, right? That's what she says. So also, I think having that amount of alcohol in one's system, yeah, I mean, 8 hours could feel like 5 minutes. Not trying to make excuses. I know people get upset with them waiting 8 hours to call 911, and I understand. But also I'm like, whoa, maybe like 8 hours, it felt like 5 minutes for them. And why would they call police if they are super, super drunk? Why would they, you know what I mean? With not knowing what actually even happened to their friends. They just know, okay, they're not answering. So one can't really apply rational thought to that situation. To be like, well, she should have done this and this. She wasn't thinking rationally and just knew that something freaky was going on. She didn't know what. So who knows? But feel free to express your opinions because I know everybody's got many different opinions about that. Just wanted to read that yeah, that was a significant amount of alcohol in the 24 hours. So I understand then why the defense keeps on saying, you know, that she says, well, it's her own statements that she can't quite remember and that she was drunk and all of that, right? Okay, so then it said many of the friends who had 1122 King Road when police arrived also stayed in the same hotel room for the night of November 13th of 2022. So apparently after the 911 call was made and all the friends were there and everybody's passing around the phone and freaking out, then they went to stay in a hotel room that night. That I didn't know that before. So, okay, so there's that as well. And the conclusion says, for the reasons addressed above and in Mr. Kohberger's initial brief, the court should grant Mr. Kohberger's motion in limine to exclude DM from using the words bushy eyebrows to identify the intruder that she saw and to exclude DM from identifying Mr. Kohberger based on bushy eyebrows. I mean, the defense could always trim his brows for the trial. I'm not saying do that. I'm just saying, yeah, he could always trim his brows. Some people have even speculated that he did trim his brows, that when they see him in the courtroom, especially the initial appearance, everybody was like, oh my word, did he like trim his brows? I'm like, I don't know. I don't know if he trimmed his brows or not. Okay, next document from the defense. Reply to the state's objection to motion in limine number 6 regarding Nolan and touch and contact DNA. So they said Mr. Kohberger will address each objection in order. And so he is arguing here very much about the use of the word touch DNA versus trace DNA and all of that. We've gone over this in the previous live stream. This is just another document about it, where it says, in further support, the state offers a single article which references sampling methods for touch DNA. It ignores the articles cited by Mr. Kohberger, which are reviews of the literature. Pay attention to that, because later they want to claim that he is on the autism spectrum disorder, that he has a coordination disability, and that shame, he can't face the death penalty because he's just so severely compromised. But I'm like, but he's the guy like leading the way with the defense here. I know he's the defendant, but he was studying his PhD in criminology, and he's definitely chipping in of like, it ignores the articles cited by Mr. Kohberger, which are reviews of the literature, and like, you know, he just has to correct all these things from what I'm reading. That's my interpretation of it. Remember, I'm not a lawyer. So, okay, I just wanted to show you that. Yeah, that's the only one for there. Okay, next. Are we ready? Are we all good? Please like and share if you like summaries of these documents. Okay. This is from the defense. Reply to the state's response to the defendant's motion in limine number 2 regarding vague and undisclosed expert testimony. Okay, comes now Bryan Christopher Kohberger, by and through his attorneys of record, and hereby replies to the state's response to motion in limine 2 regarding vague and undisclosed expert testimony filed with the court on March 17th of 2025. Latah County began prosecuting Mr. Kohberger in December of 2022. Discovery was filtered to Mr. Kohberger in a slow, disorganized, and tedious fashion. So here, this entire document of 16 pages tells us that the defense is saying they're like so overwhelmed with the absolute terabytes of information, and it's not categorized well, it's not organized, it's not labeled. We've heard that before when we've watched some of the hearings as well, and I can only imagine that really, that must suck. I mean, for me to just work through all these documents, at least they are labeled very well. But I'm like, can you imagine just having, like sometimes if I get a FOIA request, right, in a case, and then they just, I'm going to say the South African word again, hey, they just gooi things at you. That means throw in South African, in Afrikaans, gooi. They gooi things at you and you're just like, what is this? Like, how does this picture even relate to the case? Like, what are we looking at? What's happening, right? So, whoa, in this case, there must be so much stuff, and the defense is not happy with how the state has been organizing it. So they said the state's disclosures were, for the most part, abysmal. Okay? To assist the court, Mr. Kohberger appends Exhibit 1 to this motion as a guide to the chronology of the disclosures and the lack of detail. It identifies each expert and the limits of the disclosure. So this is a whole complaint about how things were organized. And this document, I'm showing it to you, it's called, again, Reply to the State's Response to the Defendant's Motion in Limine number 2, Vague and Undisclosed Expert Testimony. The reason I'm telling you that is because this is pretty interesting to see who all they're going to be calling, you know, to the stand. So like they say, as an example, initial disclosure 12/18/24. This witness is an expert from NMS Labs that performs testing for substances a deceased has consumed. His work encompassed EC, so Ethan Chapin, Xana Kernodle, and Kaylee Goncalves. Reports are included. No other opinion has been provided. So this document, if you want to read more, I would recommend it. I did highlight some parts for you, so let's just go there. Okay. It said, the state does not disclose SA Balance's review of reliability. The state is creating wiggle room for Balance to testify to something undisclosed at this time. This is now about the cell phone records of Kohberger. This particular area impacts 7 minutes of time and exculpatory information. This is the 7 minutes between 2:47 and 2:54 a.m. The state applied for search warrants and its arrest warrant claiming Mr. Kohberger's phone stopped reporting to the network at 2:47 a.m. The state later had to concede, based on its own discovery disclosures, that the phone went off the network at 2:54 a.m. Between the time of 2:47 and 2:54 a.m., while the phone was on and receiving service, it was utilizing cell towers. The phone was not stationary and utilizing only one tower. The phone was moving during the 7 minutes. During the 7 minutes, the towers hand off service as the phone is moving. These handoffs, once analyzed, locate the direction of movement and the location of the phone when it stops reporting at 2:54 a.m. The state asserts that SA Balance mapped this data but has not produced it. So the defense is saying, there, those 7 minutes that they got wrong on their previous documents and search warrants, yeah, that would show that he was going in the opposite direction, like literally west instead of east. That's what the defense is saying. He was going stargazing at that, what was it called? That Wawai Park or whatever, his favorite, which was actually closed. But never mind, in that direction, he loves stargazing, he was going out there. Apparently it was a little cloudy that night, but who knows in all the areas. So I just think an alibi would need somebody else to confirm that, right? To meet the standard. So then it says, with the help of this very expert, I'm just going to the highlighted parts, the state sought and received AT&T phone records of Mr. Kohberger from June 2022 through December of 2022. The state does not have connection between Mr. Kohberger and anyone that was at 1122 King Road. Now I'm highlighting that because the rumor is still going around. It was how it was initially reported, but later over court hearings and documents, it was debunked that Kohberger was stalking the victims. There's still rumors out there that he was connecting with them on Instagram, that he was contacting them all the time. Remember that? Apparently not. Apparently there's no actual social media or physical connection between or the house, Kohberger and the house, or Kohberger and the victims. Okay, so the state puts this information out to attempt to establish a connection. While the state has chosen not to disclose the analysis, Mr. Kohberger has disclosed the analysis. The analysis shows the falsity of the state's expert slide. The real analysis is exculpatory to Mr. Kohberger. This must be excluded from the state's presentation. Now here they say the state has not disclosed an analysis or where SA Balance will claim the phone was located in those 7 minutes. These are 7 critical minutes that contain exculpatory evidence. Again, saying he's going west instead of east. Okay? And here they are just quoting this SA Balance guy saying page 28 shows a map that includes 1122 King Road, Moscow, Idaho, represented by the CS icon and a yellow circle that represents a 100-meter radius around the crime scene. Balance will explain that he conducted analysis of all the cell sites in the area that provided coverage to the crime scene and identified any cell sites that drive test data showed coverage that included this 100-meter radius around the crime scene. Then the defense says the state has not disclosed this analysis. Pages 29 and 30 represent any time that the 8458 phone utilized a cell site identified as part of page 28 between the hours of 10 p.m. and 4 a.m. 23 separate instances between July 9th of 2022 and November 7th of 2022. So that is where stalking allegations come in, because his cell phone used a cell tower in the similar area as the crime scene, right? So his cell phone was in the same area. So one could guess, you could speculate he was stalking them or stalking the house or planning this, or who knows. But he could also just have been driving around in the area. Unapologetically authentic. Thanks for being a member for 22 months. You said, very proud to be a Grizzly. I had to step away for a mourning period. I'm so sorry to hear that. Good vibes, please. Absolutely. Thank you so much for being here. So then it says the state has not disclosed its analysis. In its 2/17/25 disclosure, it was these times the state claimed was cumbersome and a waste of time to analyze. So the state's saying, you know, those 7 minutes, they don't matter. I think they do. Mr. Kohberger provides Exhibit 2, the affidavit of Cy Ray, to support. That's going to be the defense expert when it comes to all this with cell phones, and he's got a lot of experience. He's also testified at court hearings, and his affidavit is very interesting. So we're going to be looking at that. It says Mr. Kohberger provides that Exhibit 2, affidavit of Cy Ray, to support his motion to exclude SA Balance's testimony. This witness must be excluded. Interesting. Then rebuttal disclosure of 2/17/25 said this expert was disclosed for the first time in rebuttal disclosures. His area of expertise and proposed testimony, it says Dawson here. His area of expertise and proposed testimony that Madison Mogen was severely impaired by her intoxication and could not fight back is not one that is challenged by experts in Mr. Kohberger's disclosures. So we didn't know that before, that there is an expert that says that if the victims didn't have, like especially one of them here mentioned Madison Mogen, if there were no defense wounds or something like that, then what they're saying is that she was severely impaired by her intoxication and could not fight back. So that's also new information we hadn't heard before. Heather says, thank you for good content, great work. Thank you so much. Okay, so we keep going to I think we're going to get to the affidavit later. This supplemental disclosure says, and please know that I've read all of these pages for you, and I'm bringing you the highlights, the most interesting bits, in my opinion. Of course, it's in my opinion. Others might read it differently. Lawyers will definitely read it differently and maybe find something else that's more interesting. But to us, I think what I've found is what you would find interesting. So, and the documents, the source is linked in the description box, right? It's on the Idaho Cases of Public Interest website. The Angel Rock with Laura Lay, you said, so glad to catch you live. My younger son passed away unexpectedly. I'm so sorry to hear that. Oh my goodness. And you said, I'm starting to get caught up on my favorite channel, Grizzly True Crime. Oh, thank you so much for being here and for being a member for 26 months. And I'm so sorry for your loss. Okay, so This says the disclosure states that there are 49 devices and digital data sets that this witness will testify there is no connection between Mr. Kohberger and any of the following individuals. So this is Madison Mogen, Kaylee Goncalves, Xana Kernodle, Ethan Chapin, DM and BF, the other two roommates, right? And then these ones I don't know the exact names, but JD, JS, MM, DoorDash, EG, or EA. The rest of this witness testimony will be about the download of other devices. And then this one said, Sutton, this witness works as an expert in blood spatter. This disclosure contained an expert report. The reason I highlighted that is like, I just wanted to make a comment. Whoa, can you imagine that work in this case? What a horrific crime, a quadruple homicide. The victims allegedly stabbed. The blood spatter expert, whew, he must have had quite a bit to do there. Okay, so we've looked at that one. Next, the reply. This is another defense document. Reply to the state's response to the defendant's motion in limine regarding excluding Amazon click activity evidence at the trial. Obviously, the defense wouldn't want that in because the state's alleging that Bryan Kohberger, they say that they have receipts that he bought a K-bar knife and sheath on Amazon before the murders and months before. And then after the murders, he was back on Amazon searching for another knife and sheath, like to replace it. And it's not like the police have found the K-bar knife. They found the sheath. It was left behind at the crime scene under Madison Mogen's body. So there's that. Bob Tesman says, thank you for staying impartial. That is why I like watching you. Thank you so much. Yes, I am perched on the fence. In this case, I am very eager to see what's going to happen at this trial. What will the evidence be? So far, what we have are these documents. And yeah, I find all opinions very interesting. All across the board on YouTube, I watch all sorts of things, all sorts of opinions, and I find it all very interesting. Looking forward to the trial, which will be lengthy. So they said the defense says, comes now Bryan C. Kohberger, Bryan through his attorneys of record, and hereby replies to the state's motion to the defendant's motion in limine regarding excluding Amazon click activity evidence at trial, filed on March 17th of 2025. And so here they say the argument is the state seeks to use expert testimony to show that a very narrow set of Amazon records of purchase and click history related to a K-bar knife and sheath makes it more probable than it would be without the evidence that the K-bar knife sheath found at the crime scene was Bryan Kohberger's, and that click activity after the homicides makes it more probable than it would be without the evidence that Kohberger had a reason to search for a K-bar knife and sheath after the homicides. I can understand why the state is going to say that, because if they can see that he bought a K-bar knife and sheath, they find a K-bar sheath at the scene, they never find the knife, and the K-bar sheath has got his DNA on it. Yeah, I can see why the state is going to present that. And then also to be like, oh, he was searching afterwards for a K-bar knife and sheath. You wanted a replacement? Okay. If he did it, then where'd you put the knife, buddy? Right? Okay. Adam Bluefire says, gee, if the trial is televised, you'll be everyone's first choice to watch. This trial will likely have heavy heat on it. I can't imagine how this trial will be. And I can't imagine how much coffee I'm going to have to drink, because that is a long trial. Not at all anywhere near my time zone. It's going to be very late nights for me, but I look forward to watching the trial with you. I do believe it will be televised, even though now there's a gag order and a lot of the hearings and things are not actually made public, right? Because there's a gag order. Some are. I think they said John Judge, the previous judge, obviously now it's moved to Ada County, right? The previous judge had said that there will be cameras in the courtroom for the trial. So I'm hoping that that's still upheld, right? Formula 1, ND44, thank you so much. So somebody says, Kohberger is toast. Is that so? In your opinion, Kohberger is toast. So there's that. Okay, now let's just go. They just explain all the things the defense is explaining in a lengthy document here, 11 pages, why it could just be AI that's coming up with suggestions of like, oh, you're looking for a K-bar knife? Why won't you also want to buy a sheath? Or like, you know, when they're saying it might not have even been him, it could have been his family, it could have been anyone, it might not mean anything, but I'm like, damn, imagine if the state can prove that, then that's quite interesting, right? So Anna Banner said, was it you that did videos of Uncle Roger on Reddit? I don't think so. I don't think I talked too much about, you mean Papa Roger? Uncle Roger. Papa Roger, who posted about the case. That was quite interesting. Didn't those posts stop after Kohberger was arrested? That was interesting. There's a lot of speculation about that. Okay, so conclusion. For the reasons addressed above, and in his initial brief, motion eliminate number 2 to exclude expert testimony, the details in this expert disclosure of Mr. Howell, motion for leave to call him as a witness, and the declaration of Mr. Howell, Mr. Kohberger respectfully requests this court grant his motion eliminate to exclude any Amazon and Amazon click activity evidence. To that, I've got to say, yeah, right. You think the judge is going to grant that? I don't think so. No, we want to see what you, the suspect, the defendant in this case, what were you buying? What are you clicking on afterwards? Why were you searching for a replacement afterwards, especially if they can't find the knife? Oh my word. Okay, so that's that one. Next, let me just have a sip of water here quickly. Okay, we've got to stay hydrated while I talk your head off. Okay, so now you know why you didn't see me for a live stream yesterday, right? I wanted to see you. There's no way. I even said on Patreon, I posted a video. I went to the Bryan Falls this weekend. So if you want to see behind the scenes stuff like that and do a little trip with me, that's on Patreon, right? But I even said, I hope I see you guys later. There's no way. These documents, there's too many. Okay, and we've got to get it right, especially because I'm not a lawyer and I'm trying my level best to understand all of this and be like, what does it mean? Okay, so this is from the defense again. See the color. Reply to the state's motion to the defendant's motion eliminate regarding witness identification by bushy eyebrows. What is this? Didn't we go over? Wait. Yeah. Was there a second one? Listen here, people. Wait. Reply to the state's response, eliminate number 7, bushy eyebrows. And this one is, we saw the Amazon click activity. Wait, we like that. There's a duplicate, so we can close this one and say, no, you don't have to save that. Cool. Next, reply to the state's, sorry, now I've got a hair in my face. Okay, reply to the state's response to the defendant's motion to strike the death penalty regarding autism spectrum disorder. Okay. So comes now Bryan C. Kohberger, Bryan through his attorneys of record, and hereby replies to the state's response to the defendant's motion to strike the death penalty regarding autism spectrum disorder filed on March 17th of 2025. Mr. Kohberger relies on his right to be free from cruel and unusual punishment. His right to due process, his right to a fair trial, his right to counsel, his right to present a defense, his right to reliable sentencing, determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, right? So the argument is the Atkins standard for intellectual disability is much more than low IQ. Atkins versus Virginia. Mr. Kohberger fits the criteria set forth in Atkins in the following ways: impairment in communication, reasoning, social skills, and understanding the reactions of others. His deficits developed at an early age and continue to the present day. ASD, for autism spectrum disorder, is not something one outgrows. Very early in his education, he was treated as a child with special needs, evaluated psychologically, and provided with instructional support. He was observed as rocking in the classroom, inattentive. He had poor fine motor skills. He received reading support, speech therapy, reminders to stay on tasks, more time for homework, and organizational support. He lacked social, emotional hold on. Sandra says, little will be great to see justice for each of these young victims. Absolutely. Thank you for being a member for 38 months. Okay, so he lacked social, emotional reciprocity and had few friends. He did not understand non-verbal communicative behaviors used for social interaction and had an inability to develop, maintain, and understand relationships. That's okay, but I think if he is convicted of murdering 4 students, I don't think that this reasoning takes the death penalty off the table, do you? This is a death penalty case, right? So it says the state seeks death when Mr. Kohberger is a person with an intellectual and neurodivergent physical disability. Like people with intellectual disabilities, Mr. Kohberger's adaptive functioning is impaired. He lacks the skills to function in the real world of daily living, self-care, socialization, and communication. People with an IQ above 70 can still qualify as intellectually disabled due to diminished adaptive function. Now, the reason I find this just ironic in their filings, in the defense's filings, is that 1 minute they say this and the next he is like absolutely calling the shots, you know what I mean? Like he's guiding them through things. So I don't know, I think you can't have it both ways. You got to pick a strategy and go with it. Jennifer said, thoughts and prayers to the family of the victims. It seems to be finally moving forward for justice, but I know their hearts still hurt. Thank you for the excellent coverage. Thank you, Jennifer. Yeah, I think it's going to happen this year. You know, normally it's like, pencil it in. I still would say pencil it in. Or if you want to write it in pen, make sure you have topics in your diary. Okay, so we've read that. Okay, let's go here. It says lesser culpability. Mr. Kohberger has at all times asserted his innocence should he be convicted of this crime. His neurological physical disorder may very well be the reason the jury misjudges him. Okay, that's what the defense is saying. Oh, and this was just, this document is 59 pages, but it's because they're citing another case. So if you want to read all of that, yeah, that's what the rest of the document is, them citing another case where they're backing up the argument for what they've just said, right? Now, Chicken Opera says, then how did he have a driver's license? Not only that, I mean, he was a PhD student in criminology. He was a teacher's assistant as well. Like he was teaching students, you know, like he was doing very well. So he was the one driving the vehicle when he got pulled over as well, you know, when the police stopped him when he was going on his way home with his dad. And later, I can't remember exactly where in these documents, but he claims to have a like coordination disorder and says that he couldn't have committed these crimes because he wouldn't have the speed to do it. His coordination wouldn't be up to par for someone who could do that, especially in the amount of time. And I'm like, but you you literally were the one driving the vehicle. If that was true, you wouldn't. There's other evidence to disprove that, okay, in my opinion. Libby said, didn't BK take martial arts too? Sounds familiar. If you haven't ever checked out my playlist on this case, man, we did a deep dive on his past. You know, when we look at everything like where was he born, who's his family, like what did he do? Where did he work? All the things. We went over that as well. Cherry said, my son has ASD and very much like that list. He's not a serial eater. YouTube friendly. Thank you so much for the YouTube friendliness. I really appreciate that. Okay. This one is another defense filing, and it says, notice of filing affidavit in support of the defendant's objection to the state's motion in limine relating to or regarding AT&T timing advance records. Now, this gets quite interesting. Because let's say the state previously, you know, with that little time frame, the 7 minutes, if they mess that up in the documents, that kind of sucks. And now they say, well, those 7 minutes don't even matter. They do matter. Accuracy matters. And so here is a big battle between the defense and the state about these the AT&T timing advance records. Okay. So this comes now, Bryan C. Kohberger, by and through his attorneys of record, and hereby files the accompanying affidavit of Cy Ray. This is a little bit of a longer one we're going to go through now, in support of their objection to the state's motion in limine regarding AT&T timing advance records filed with the court on March 17th of 2025. So if we go down here, the affidavit of Cy Ray, which will be a defense expert. Okay, he says, I'm an adult over the age of 18, have personal knowledge of the facts set forth in this affidavit. I've been working in the field of call detail record analysis for over 25 years. I became a certified police officer in the state of Arizona in 1996. I worked with my first set of AT&T records in 1997. I spent nearly 20 years in law enforcement in the primary role of a detective. I've worked hundreds of death investigations and consulted on over 1,000 homicide cases in my career. In my role as a detective, I gained extensive experience utilizing call detail records and exploiting cellular networks for investigative related purposes. So he goes on to clarify his experience, okay? So I'm going to go forward now, otherwise we will be here all day. Sam says, for helping me through recovery from my op last week. Oh, I'm so sorry to hear that. I hope that it goes well for you. Happy recovery to you. Eve Loves God said, not likely that autism diagnosis will save him from the death penalty, and his impairments are low as he is high functioning. I don't think it's likely it will save him from that either, not that reason, right? Thank you so much. So now if we scroll down, because he's just saying all his experience, I want to take you to the battle. So he said, in August of 2021, I was approached by an FBI agent to assist in analyzing a type of record set identified as AT&T Timing Advance Report. And it was the first time I was made aware of this type of data from AT&T. Upon request, I can provide the date, time, location, and FBI agent I assisted with the record set. So you can see that's before these murders even happened. This guy, who's going to be a defense expert, who is a defense expert in this case, okay, I'm sure they're going to call him, is adamant that these records already existed. The state is literally saying they couldn't get AT&T Timing Advance records for Bryan Kohberger because the murders occurred before those records were ever available, right? They're saying that they could only get it from June of 2023. That's what the state says. The defense is saying the state's lying, that those records do exist, and here's a affidavit from their expert saying why. Okay, so let's scroll down here. Formula One says if they go down the route of autism, he has to fully admit to the crime. Lawyers that were talking about the case on YouTube. Oh, thank you so much. Thanks for relaying that to us. Now, they say AT&T Timing Advance records in the state's possession. The defense claims the state has it. Not only that they're saying, no, it wasn't available. The defense says the state has it and they're hiding it because they think they're hiding exculpatory evidence. During this investigation, law enforcement obtained the following AT&T Timing Advance data. 2 of the victims had AT&T phones. Law enforcement obtained AT&T timing data on both of their phones. Law enforcement developed an early investigative lead in this case. That person had an AT&T phone at the time of the crime. Law enforcement obtained his AT&T Timing Advance data. Now, yeah, a lot of people online are focused on that of like, what? Law enforcement developed an early investigative lead in the case, which wasn't Kohberger. Who's that? That person had an AT&T phone at the time of the crime. Law enforcement obtained his AT&T Timing Advance data. Law enforcement also requested a tower dump consisting of AT&T Timing Advance data. This request involved AT&T providing all of the connections between 2 specific cell sites in Moscow during a 2-hour period. The data was produced. There was AT&T Timing Advance data. In all, there were over 3,800 AT&T mobile phones identified in the Timing Advance tower dump data. The AT&T Timing Advance data was obtained by the FBI using an internal source at AT&T. Mr. Boyd Jackson, who is not associated with the GLDC working group. GLDC was not used to obtain this data, and a forensic examination of the AT&T Timing Advance records in the state's possession show that Mr. Jackson's association with the reports. So now they talk about the chain of custody. You can pause to read or go find the document. I'm going to my highlights of what's the point? What's the defense trying to say? They said, evidence in direct contradiction to the state's motion. In my review of this investigation, I have read numerous emails sent and received by law enforcement pertaining to their investigation. One such email, dated 11/15/2022, so that's the 15th of November, that's like 2 days after the murders, okay, was sent to Prosecutor Ashley Jennings at her Latah County government email address. This email is from Moscow Detective Lawrence Mowry. The email is informing Mrs. Jennings of Detective Mowry's recent contact with the FBI Special Agent Balance. There's that name again from earlier, who will testify for the state. The defense wants him to not be able to testify. SA Balance informed Detective Mowry that AT&T can provide timing advance data and to make sure it is listed in the search warrant. Detective Mowry is specifically asking Prosecutor Jennings to make sure that the AT&T timing data is listed in the warrant prior to the report ever being distributed by the working group known as GLDC. Mrs. Jennings did respond to Detective Mowry's email, inquiring on the specific verbiage needed to obtain AT&T timing advance. This email is abundantly clear evidence that Mrs. Jennings was not only aware of the existence of AT&T timing advance in 2022, but also shows her intention to obtain it through legal process from AT&T. So why the state saying that no, they couldn't get it, they couldn't get that for Kohberger, is interesting. The defense is like saying you could, you wanted to, there's emails going around where it seems like you're going to ask for it, so how can you say you don't have it, right? And the defense, again, would be claiming that it contains exculpatory evidence. Okay, this email communication with Prosecutor Ashley Jennings is the same Prosecutor Ashley Jennings who filed this current and contradictory motion stating AT&T did not produce timing advance records in 2022. There's clear and convincing evidence that not only was the FBI able to obtain AT&T timing advance records in 2022, but they did so with the knowledge of the prosecutors involved in this case. Missing AT&T timing advance. In my review of this investigation, based on my training and experience, it's incredibly unusual that the defendant's AT&T timing advance records were not obtained by the FBI. The FBI demonstrated the ability to obtain AT&T timing advance in November 2022 by obtaining AT&T timing advance records on over 3,800 mobile devices, none of them being the defendant's. And then they go on to argue that point. And so to the highlighted, it says, it is my expert opinion. AT&T timing advance data did exist for the defendant's AT&T mobile device in 2022, and it was requested from AT&T by the investigators involved in the case. The investigators previously demonstrated the ability to obtain AT&T timing advance data in 2022. Failure to produce the defendant's AT&T timing advance data is either a gross deviation from standard practice or intentionally withheld from release in discovery. I find that all quite interesting. How about you? It is my expert opinion, this is the conclusion, in reviewing all the evidence that has been disclosed by the state that A, AT&T timing advance data was available on the defendant's phone in 2022. B, there's overwhelming evidence showing the state obtained all this data. There's no doubt the author of this current motion, Prosecutor Ashley Jennings, knew or should have known AT&T timing advance data did exist in 2022. She was directly involved in the legal process of obtaining it and was aware of the product created from it to further the investigation. The current motion is, they said the state's current motion is a deliberate misrepresentation to the court to further conceal false statements used to obtain probable cause against the defendant and conceal exculpatory evidence from discovery. Interesting. What do you think about that? As we read this, let me know in the chat, and then afterwards, if you're watching the replay or just afterwards anyway, please comment below as well. Okay, so we have gone through all the defense's documents now. The Bushy browse, the touch DNA, the vague and undisclosed expert testimony, the balanced ones that relates to this AT&T stuff, the Amazon click activity, the self-authentication records, the motion to strike the death penalty, and the AT&T advanced timing records. Okay, now we go to the state's documents. Now they're purple. We're switching over to some of the state's recent documents. Now remember, it's not in order. I downloaded all the documents, read all the new filings, picked out the ones that I think are most interesting to bring to you, and I decided to, let's first look at all the defense documents, then we look at all the state's documents, because then we can follow it a little bit more easily, I think. So I hope it's working for you. State, okay? State of Idaho plaintiff versus Bryan C. Kohberger. The dates, by the way, this is on the 24th of March of 2025. So these are all the recent filings since our last live stream. The last live stream, I think, was on March 22nd. And when I looked again, there were like 100 new documents. And I'm like, oh my word. Oh my goodness. You really have to follow this case. Like now, we really have to look at that site every day, every second day, just to see what's happening, what's coming out, because there's so much, right? Okay, state's reply to the defendant's response to the state's motion in limine regarding neuropsychological and psychiatric evidence. Okay, so let's go to the highlighted parts. First, addressing the issue of the defendant's behaviors and appearance as they may be perceived by the jury. The defense offers no authority, statutory or otherwise, to allow him to present evidence purportedly explaining how he may appear or behave in front of the jury. The defense is worried that based on his diagnosis, being on the autism spectrum disorder, that the jury will judge him based on his demeanor, his stare, all of that. They say the lack of, like, you know, reading the room, whatever, all of that. So they're like worried about that, and the defense, the state is saying, what? The state's unaware of any such authority, while Idaho Code 18207 does allow for the admission of certain mental condition evidence. Not even that statute contemplates the defendant offering evidence of the defendant's behaviors and appearance, much less offering evidence before even the state's case in chief begins, or presumptively trying to follow the defendant's argument prior to jury selection beginning. Not only would this type of evidence be completely irrelevant and immaterial to the legal and factual issues in this case, whether the defendant committed 4 murders and burglary, it would more likely confuse the issues, mislead the jury, and play to the jury's sympathies. These purposes are prohibited by those codes. Then it said this analysis further supports the conclusion that a defendant's appearance or behavior in front of a jury, at least when he's not testifying, is irrelevant and not evidence. What does this tell me? My interpretation is that, oh, you want to testify? That's what I'm reading. Because it's like, don't judge him. That's what the defense is saying. They're worried about how they want to bring in to evidence his diagnosis, so that, I guess, when he testifies, the jury won't judge him by his demeanor. But I mean, they shouldn't judge him by his demeanor anyway, right? Just listen to what he's saying. I hope he does testify. That'll be interesting. Oh my word, can you imagine? It'll be like, yeah, I don't know, if he committed the crimes, sure, what a moment that would be. Like, what a thesis. Him testifying, how much he would have then practiced, thought about it, all of that. I can't imagine. If, of course, he's innocent till proven guilty. Kirsty, welcome. Okay, so it says the defendant's appearance and behaviors in front of a jury are not material or relevant. The defendant argues that he has a developmental coordination disorder. That means it was not possible for him to commit these crimes because he lacked the necessary speed and coordination. But that is not what his neuropsychological evaluation found. The expert who conducted the evaluation, Dr. Orr, listed developmental coordination disorder under the title diagnoses for which Bryan met criteria in the past. Emphasis added. Dr. Orr clearly explains that motor problems have not impacted his functioning significantly in many years. To the extent the defendant currently has any motor impairment, even according to his own expert, it affects only his fine motor dexterity and vulnerabilities in visual motor functions. The examples she uses for fine motor dexterity include when he had poor handwriting and trouble tying his shoes in the past. She asserts that he continues to have difficulty with manipulation of tools even as an adult, but only per parent report. She also points to observations during the examination that the defendant moved his whole arm and repositioned his upper body slightly to manipulate the items effectively. So that's another argument that the defense has of why he could not have committed these murders, would be this this developmental coordination disorder. And so it says, finally, it now appears the defendant wants to offer evidence that his OCD, which is obsessive compulsive disorder, and ASD are actually physical conditions as opposed to mental conditions. As stated above, this is new, and the state is attempting to understand how this could be relevant or admissible. The state will note that not having this knowledge before, the state's motion in limine was not drafted to address it. Okay, so that's what that issue is there from the state that they are addressing, right? Okay, next. State's reply to the defendant's objection to the state's motion in limine regarding admissibility of demonstrative exhibits and memorandum in support. This is about the house, the model of the house. Okay, so we're going to what's coming up still is we're looking at the 3D model of the house, Kohberger's family members potentially testifying, Kohberger's crime scene essay, and the state's response to the AT&T advanced timing records, which actually, before I read this 3D house model, let's just go to this because we just recently talked about this from the defense, right? So this was the state's reply to the objection to the state's motion in limine regarding AT&T timing advance records. This is what the state is still saying. Timing advance records refer to data that is used by providers to estimate the location of a mobile device. The collection of this data is necessary for cellular network to work properly. Carriers do not retain this data indefinitely. Regarding AT&T, before June of 2023, AT&T retained timing advance records for 7 days. These records were not routinely provided in response to legal demand prior to June of 2023. After June of 2023, AT&T started providing these records pursuant to legal demand and began retaining timing advance records for 13 months. In this case, the homicides occurred on November 13th of 2022. Bryan Kohberger was identified as a suspect on December 19th of 2022. Search warrants for his AT&T records were executed on December 23rd of 2022. At this point, timing advance records were not available for Bryan Kohberger's phone to cover the relevant time period, November 13th of 2022. Despite defendants' repeated assertions, the fact of the matter is that AT&T did not provide timing advance records to law enforcement for Bryan Kohberger's phone. The state is attaching affidavits from AT&T verifying that the state did not receive timing advance records for Bryan Kohberger's phone. See State's Exhibit S1 and S2. Carla says, my son is low functioning ASD and has low dexterity. BK isn't dumb. Do OT find motor pinching exercises? Give me a break. Carla, thank you for the sticker. So here, I mean, that makes sense if they only retained it for, you know, how long did they say there? 13 days or 7 days, for 7 days, and they only identified Kohberger as a suspect and arrested him, you know, December 19th. As they say, as a suspect, December 19th is when he was identified. So the state's argument could make sense. The defense is saying, you have those records, you know you've got them, and you also have one for some other suspect they had on their radar at the time. Okay, so this is basically just, as you can see, the search warrants and things, which it just shows that they had applied for it, but they didn't get it. Let me just see if I highlighted anything else. No. Okay. So now we go back to the 3D. We've done that, okay? 3D model time. Aurora said, defense doing their job. Yeah, they're doing it. They're doing their job. They're working hard for the client, and I mean, damn, it's a death penalty case, so that is quite something. Whoa, to all 5,330 people that are here, thank you for being here to listen to me do my best to bring you all the tea, all the summaries, okay, in these documents, because, yeah, I would actually hate for you to read through all of these yourself. It can be quite something. It's quite a mission, so I'm happy to bring you the highlights. State's reply to the defendant's objection to the state's motion eliminate. This is about the 3D model of the house. Yeah, demonstrative exhibits, okay. Eventually, okay, so let's read from the top here. At the outset, it's necessary for the state to clarify the history between the parties on the issue of a 3D model. It is true that the state's initial plan was to ask for a 2-scale 3D model of 1122 King Road residence. As part of that, and at least partially in response to Ms. Taylor, that's the defense attorney's October 2023 request for additional information, the state initiated inquiries for underlying supportive data for its own review and to share with the defense. Eventually, the state realized that there was not any need for a 2-scale model and ultimately settled on proposing a not 2-scale 3D model as a demonstrative exhibit. So let me know what you read from that. Remember, I am not an attorney, so all I'm thinking is, damn, you decided to destroy the house, and I think, therefore, it's very important to have a 2-scale model. Make the best house model you possibly can, you know. But okay, I'm sure the state will have whatever they need for the jury to understand the layout of the house. I'm sure they took plenty of photographs and all of that as well. I would hope so, right? Okay, so that is what they said there. I didn't highlight any of the others because they go on to explain it. The state recognizes that it will need to establish a foundation that the 3D model fairly depicts or represents the floor plan of 1122 King Road on November 13th of 2022, and that the use of the model will be helpful to witnesses in explaining their testimony and to the jury in understanding the evidence. Okay, so that is what they say there. Anything else here? These are the emails between the attorneys just discussing that, right? Do not email any of these people. I do see most of it is redacted, but Yeah, these are just the emails that go as part of the exhibits to talk about this 3D model of the house, right? So again, the state recognizes it will need to establish a foundation that the 3D model fairly depicts or represent the floor plan of 1122 King Road on November 13th of 2022. It's such a oddly built house. It's so complicated. You know, it's a strange home that it was, and now it's demolished. So I just think for risk assessment, make sure that the witnesses and the jury will clearly understand the layout of that house and everything, right? Helen says, I fear they have lost any examples of acoustics between one floor to another, brick floors, extensions of drywalls, right? Okay, now let's look at this one. Now this is about Bryan Kohberger's family members potentially testifying. The state's reply to the defendant's response and objection to motion eliminate regarding immediate family members in the courtroom. Again, this is a document from the state. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully replies to that label I just read. The defendant requests that members of his family be granted the same rights as the victim's family. Damn. By the way, they said here the state is in agreement that immediate families should logically include step-parents and relatives by marriage. The defendant stipulates to the individuals listed within the state's Exhibit S1. Therefore, the state moves the court for an order allowing the family members listed on the state's Exhibit S1 to remain in the courtroom during the entirety of the trial against the defendant. Okay? So Kohberger is saying that the members of his family should be granted the same rights as the victim's family. However, the immediate families of homicide victims have constitutional and statutory rights to attend pursuant to Idaho Constitution and all of that. So here they say, in addition, the state may call members of the Kohberger family to testify at trial. Prior to the start of the trial, the state anticipates it will motion the court, or the court will on its own accord, generally exclude testifying witnesses from the courtroom so they cannot hear other witnesses' testimony. Meaning, if they ask Kohberger's mom, dad, and sisters to testify at this trial, they're not allowed to be in the courtroom and listen to other witnesses' testimony. So they're saying, calm down, Kohberger, because we're going to ask your family to testify. So don't worry about where they're going to sit because they're not going to be in the courtroom. Basically, right? Okay, so that is that document. This one now is, this is going to, and this, we already read this one, right? Yeah, so we're on the final stretch here. I'm going to try to keep this stream under 2 hours, wish me luck. We're at 1 hour 17. Here we go, we're getting to Kohberger's crime scene essay. Now remember, he did a survey. He was obviously studying, he was getting his PhD in criminology, all of that. We've gone over his whole study history at DeSales University and then going to Washington University, all of that in the past, okay? So I don't find it strange that he wrote this essay. It's just interesting to analyze now, as we had, it was interesting to analyze his survey that he made before, because he's accused of murdering 4 people. So yeah, he took the studies a little too far, if he's the guy that did this, right? Okay, state's reply to the defendant's objection to motion in limine. Regarding self-authentication of records in reliance on IRE and all of that, right? Comes now the state of Idaho. Again, this is a state document. Okay, so firstly, what they go through here is, again, the surveillance footage they have. They're going over, the state seeks to rely on self-authenticating evidence as opposed to calling foundational witnesses in order to accomplish the same visual aspects, videos, basically. It is understood that admission would be, and the essay, contingent upon the state laying a proper foundation with a certificate or affidavit, right? And so it says, replying specifically to the defendant's response. So, you know, in a previous document, the defense was complaining of, like, we have all this stuff and we don't even know what they're going to use it for. Like, what are they going to do with this Linda Lane surveillance footage? There they say, well, what we're going to look at is the state would seek admission of this footage pursuant to that code. The relevant footage is taken on November 13th of 2022, approximately 0.3 miles from 1122 King Road, the crime scene. The state may rely on video footage around 3:29 a.m. So they're giving them some timestamps. This is the state giving the defense basically timestamps of how they're going to use these videos. So I've highlighted some of the most interesting ones. Albertsons, Clarkson, Washington, that was on his third trip. Remember, he went allegedly to the King Road residence. This defense says he went another way, but let's say if he went to the residence, committed the murders, allegedly, that's what he's accused of, went back home. Back to the house, back home, selfie time, and then down to Clarkson, Washington to buy groceries or what? So far, you want to go on such a far trip? Never mind, he can have a day, a day outing there. So it says this footage is maintained by Albertson's Grocery in Clarkson, Washington. The state would seek admission of this footage. Pursuant to the relevant footage is taken on November 13th of 2022. The state may rely on video footage from approximately 12:46 p.m. to 1:06 p.m. to show the defendant's vehicle and actions hours after the homicides. So that is, the state again is giving them clues or actual timestamps of what they're going to use, because the defense is complaining of like, what is all of this and how will you be using it? This is how they'll be using it. What they could see in that Albertson store, which is why we did a little recap before, is Kohberger in like surgical gloves buying something at self-checkout. Amazon financial and user records for Bryan Kohberger. It says the certificate was included with an Excel data file that details Bryan Kohberger's subscription information and order history from January 5th of 2022 to December 13th of 2022. At trial, the state intends to offer the certificate with the attached records as an exhibit. The defendant was provided this information on May 18th of 2023. Then they talk about the click evidence and everything as well, like what it is, what's the timestamp, why they've got it, what they're giving to the jury. The AT&T phone records for Bryan Kohberger, Madison Mogen, and Xana Kernodle. The above AT&T phone records are relied upon by the state's expert witness, Nicholas Balance, as detailed in his expert disclosures, which the defense expert is arguing with, saying they don't want that Balance guy to testify because he's getting things wrong, according to the defense. A certificate of authenticity is attached as Exhibit S3, which was included with a return for Bryan Kohberger's AT&T records for November 12th to the 14th of 2022. This was provided to the defendant around April 4th of 2023. Bryan Kohberger's AT&T records from June 23rd of 2022 to December 23rd of 2022. They're also looking at this bagel shop video surveillance video for November 13th of 2022. It says this footage is maintained by a business. The state would seek admission of this footage pursuant to. The relevant footage is taken on November 13th of 2022 from approximately 1:40 a.m. to 2 a.m. This evidence provides a timeline of events for Kaylee Goncalves and Madison Mogen before the homicides and corroborates the state's witnesses' testimony. Okay, and then previously, you know, they said Bank of America records for BF and Xana Kernodle, and now they're saying the state no longer intends to rely on this evidence. So you could see those examples, right? To the highlights we go. This footage of Cafe Artista video surveillance says this relevant footage is taken on November 13th of 2022 at approximately 1:40 a.m. This evidence provides a timeline of events for Kaylee Goncalves and Madison Mogen before the homicides and corroborates the state's witness testimony. Remember, they went to the corner club, Kaylee and Madison, and then they walked to that food truck, and we got to see all those videos and analyze those. And on the way, we heard that, what did you say to Adam? I told him everything. Remember all of that? It's probably all of those. It's the surveillance video, right? The corner club video surveillance as well from November 12th to 13th. So they'll show the jury, I'm assuming all of this, that's what it sounds like they're going to do. The Elantra footage, they're going to be showing the victims before they were murdered. Like, look, here they were at the corner club, then they went to the food truck, and then, you know, they got home and all of that. Okay. So then they say the relevant footage from the corner club video is taken from November 12th of 2022 at approximately 10:20 p.m. through November 13th at approximately 1:37 a.m. This evidence provides a timeline of events for Kaylee and Madison Mogen. Then there's the corner club financial transaction, Costco. We talked about Costco in the last stream as well. Costco surveillance video for November 13th of 2022. This footage is maintained by a business, Costco Wholesale in Clarkston, Washington. That's when Kohberger went there the next on November 13th in the afternoon. The state may rely on video footage from approximately 11:59 a.m. Here it says the state has attached relevant evidence that would be introduced to show the defendant's knowledge of crime scenes. That was DeSales student records regarding Bryan Kohberger. And that's what we'll be looking at, which, sorry for the paper flapping. I just want to move this and all my pens, oh my word. Look, all my pens out. Hold on one second. So that is called Crime Scene Scenario Final. It's an essay that Bryan Kohberger wrote on May 5th of 2020 while he was a student at DeSales University. It's a 12-page report, and we are so going to go over it. This is the last document we're going over today. Okay, so that's the exhibit. We'll get to it. Then Dick's Sporting Goods record of sale for Bryan Kohberger. The relevance of this information is that Bryan Kohberger purchased a black balaclava from Dick's Sporting Goods on January 10th of 2022. Wintertime. Could be a normal purchase, unless, of course, he decided to wear that in Moscow, Idaho, while committing murders. If so, if the state can prove that, then that's interesting. If they can't, then it's irrelevant, obviously. So the mask is the same type of mask described by DM that she witnessed worn by a male in the residence on November 13th of 2022. Then DoorDash records for Xana Kernodle and Ethan Chapin. It said the state may rely on the attached records from DoorDash regarding a delivery to 1122 King Road on November 13th, 2022 at 3:59 a.m. Okay, then E&S Services, it says surveillance for November 13th of 2022. And it says at around 5:26 a.m. showing the suspect vehicle after the homicides in Pullman, Washington. The state may rely on video footage from Floyd's Cannabis Company from November 13th of 2022 at around 3:02 a.m. showing a white sedan on State Route 270 between Pullman, Washington and Moscow, Idaho, approximately 1 hour before the homicides. Then, Kohberger was a crypto boy. Forrest Dax, Crypto.com financial records for Bryan Kohberger. Is that so? He was trading crypto, okay? A little bit of Bitcoin. I don't know if he was. It seems like it. They said so in another document as well. Grub truck video surveillance. We've all seen that, right? Whew. Remember when we all went to the website, all the YouTubers, I was there as well. We were looking at let's find the exact timestamp when they say that Kaylee and Madison were there, and we were looking at that and just everybody around them as well, of course. Grub truck surveillance video for November 13th. The relevant footage is taken on November 13th, 2022 from approximately 1:43 a.m. to 1:53 a.m. Latah County Sheriff's Office Deputy Darren Duke body cam from August 21st of 2022. We saw some of that as well when police had responded to the house, right? National Weather Service records for November 12th and 13th. Oh, are you going to debunk the stargazing state? I think they're like, let's get the Weather Service record, shall we? It was completely cloudy. How was the sky stargazing? Although was it? I don't know. We'll have to hear from them at the trial, right? Okay. PayPal, Venmo financial records for Kohberger. PNC bank records for Bryan Kohberger. Pennsylvania State Employees Credit Union records for Bryan Kohberger. All of these as well. The Petco financial records for Kaylee. The state no longer intends to rely on this evidence. We were wondering at some point why they're looking for Petco records and all these bank records of these victims. What does it mean? Is there a link? Did they find a link? But now they're like, no, we're not going to rely on that anymore. Sunset March surveillance video for November 13th of 2022. The state may rely on video footage around 3:28 a.m. showing the suspect vehicle in the area of crime scene prior to the homicides. The state may rely on footage from November 13th at 5:25 a.m. to 5:26 a.m. showing the suspect vehicle in Pullman. Here you can hear just how much evidence they're going to present. No wonder it's going to be a trial from August 11th to November 7th. And it's a two-phase trial. Guilt or innocence phase, then if convicted, the punishment phase, which is when the jury will have to redeliberate should he face the death penalty or not. TikTok user records for Xana Kernodle. The records would show Xana on the TikTok application on November 13th of 2022 at approximately 3:16 a.m. I would assume from that statement that she was on TikTok still, right up to the murder, because that's what they had previously said. But they don't say that here. Maybe she just started looking at TikTok, and I understand. If you go on TikTok, oh my word, yeah, you'll be there for an hour easily. So TJX financial records for DM, the state no longer intends to rely on this evidence. T mobile records for KG and DM as well. Under Armour transaction records for Bryan Kohberger, they say the state no longer intends to rely on this evidence. Okay, maybe they found that and there's no big deal. US chef store video surveillance from November 13th of 2022. That would be, they said the state may rely on video footage from approximately 12:42 to 12:44 p.m. when Kohberger was there. Verizon phone records for Ethan Chapin, BF and JD. BF is one of the surviving roommates. I can't remember who JD, wait. Oh, JD. Could have been Kaylee's ex-boyfriend, right? I'm not too sure. Walmart surveillance and financial transaction records. Yeah, we need those, otherwise this is not a trial. No, you need to bring that state of Walmart surveillance and financial transaction records for Bryan Kohberger, but they said the state no longer intends to rely on this. Listen. You have to bring that. Listen, state, I'm telling you, bring the Walmart records. Washington Department of Motor Vehicles, of course, we know it says for November 18th of 2022, Kohberger changed his license plate from a Pennsylvania one to a Washington one, or the other way around. I can't remember. I think it was from a Pennsylvania one to a Washington one, right? No, yes, because in Washington you don't need a front one or something like that. Yeah, so that's why they would want those records. Washington Department of Motor Vehicle registration documents for Bryan Kohberger, Washington Trust bank records and images for Bryan Kohberger, all of that. We're almost done with this. They're beginning to the essay. Washington State University video surveillance for November 13th of 2022. They may rely on this footage from 5:28 a.m. to 5:30 a.m. showing the suspect vehicle after the homicides in Pullman, Washington. So they have really looked at a lot of, obviously, video surveillance. They've plucked out all of them that they can. Ingrid de Mellem said, Boetie, jy gaan braai. Can't wait for the trial. That means, brother, you're toast, basically. You're going to be barbecued, okay? You are roasted. Boetie, jy gaan braai. Can't wait for the trial. I can't wait for the trial either, oh my word. And I know the families are also waiting, right? So, okay. These are now Amazon, you know, the search warrant records and things like that. So now we go here. It said AT&T, this is now a search warrant record from AT&T, and it says AT&T did not provide timing advance records for the phone number, which would be Kohberger's. YouTube, this is public record. I've redacted it anyway. I'm not showing anything that I'm not supposed to. These are the records of a man accused of murdering 4 University of Idaho students. Basically, AT&T came forward and said, hey, we didn't provide that, okay, to back up what the state is saying. And the defense is arguing with that. So that battle in the courtroom is going to be very interesting. Okay, so we keep going here. We're almost at the essay. Down we go, just to see that we don't skip any highlights here. Yeah, page 35. Are we ready? Oh, this is a slip from, or a receipt for Kaylee Goncalves from the Corner Club in Moscow, Idaho. All right. Steel Guitar said every trial needs a Walmart, a coffer, and a pen clicker, and a toe hold. No toe holes, no toe holes. Okay. Yeah, so, yeah, some people are saying JD is, you know, Kaylee's ex-boyfriend. When they don't specify and when we don't really know, I rather don't speculate, because there's a lot of that online already. Speculating who's who and all sorts of things. Okay, finally, we get to Bryan Christopher Kohberger's crime scene scenario final essay from 5/5/2020, when he was a student at DeSales University. I'm going to take another sip of water before this. Okay, here we go. Yeah, dogs, gang says slip equals receipt. Yeah, sorry. We call it a slip in South Africa. A receipt, yes indeed. Stefan says, I remember the 3 J's. Me too. This jack, that jack, that jack, another jack, 3. There were 3 of them. Oh my word. Okay, so this is interesting. You'll see why. Tell me if you don't think it's interesting. Like, you know, someone will say, Gisela, he was obviously a PhD student, not yet a PhD student, but he was a student of criminology. That's why he wrote this. Yeah, it's just interesting that the victim is female and that she was stabbed, and all the things that he says and how he would prepare if he was law enforcement, right? So this would be how he would properly process a crime scene if he were law enforcement, right? Mace Windu, it's always nice to see you in chat. You said, I didn't do it. What was I doing at the time? Let me see what you have, and then I'll tell you next month. But he was stargazing. Right? And now somebody's going to say, I know this case brings up a lot of debates, okay? So someone's going to they're going to call my ass out and say, Gisela, he could have been stargazing. He used to like that. That's fine if you were stargazing. Okay, I just don't think it qualifies as an alibi. You need someone to verify that. Okay, the state's asked continuously for that. And yes, I know the defense has asked the state continuously for things too. Okay, I'm perched on the fence. Okay, so crime scene scenario final 5/5/2020. Professor David Sipe, CJ361. Okay, again, this is Bryan Kohberger saying what he would do if he were law enforcement to properly process a crime scene. Arriving at the crime scene, we do like bullet points, so thank you, Kohberger, for that. Okay. Arriving at the crime scene, the first thing to be done is block off the crime scene in order to avoid crime scene contamination. Keeping people out of the crime scene minimizes evidence contamination, though many may be curious to see what occurred. The theory of transfer states that we bring something with us to the crime scene and take something away, thus skewing the crime scene from the original state by contamination. This is because the original state of the crime scene was left by the criminal suspect. A lack of contamination allows the scene to be a snapshot in time. The curious must be noted and immediately evicted from the crime scene. I speculate if it would be a normal thesis to write, but now it became abnormal because he's accused of committing 4 murders. So I would speculate, in my opinion, okay, that he may have chosen the house he chose to commit, the murders, and maybe he thought it's going to be like the perfect murders. He's going to one-up Ted Bundy or something. Who knows? Why? Because can you imagine? He would have known this is like a party house. There's really people in and out of that house all the time. He would think, and I'm speculating, that, whoa, like the chances of people just contaminating this crime scene is huge because there's so many students there. People would be running through the house, and it is actually what happened when the 911 call was made. Yeah, there were people in the house and running through it. So he'd probably be relying on that, on that knowledge of his to be like, they're going to definitely contaminate this crime scene and then I'll be exonerated. So the curious must be noted and immediately evicted from the scene. People to be kept out of the scene include unauthorized civilians and any more than the absolute minimum number of law enforcement agents and forensic crime processors. Waiting for backup to arrive, I should stand guard at the scene, preventing these unauthorized people and even holding back eager officers from entering the scene. I must call my immediate supervisor and inform them of the deceased white female who is approximately 35 years of age. Was he given the task to pick that victim, to make up a scenario? Or did he just make up the scenario? Because then it's oddly specific of a deceased white female who's approximately 35 years old and was stabbed. Bro, now you're accused of stabbing 3 females. They were 20 and 21 and 1 male student. Like, okay. Right, so it says I must obtain an initial search warrant to search the scene. Failing to do so will mean that evidence is inadmissible. This is another reason why holding personnel from entering is key. The coroner must be called in order to pronounce the woman dead. He doesn't say the victim. Maybe this is just how he's supposed to word it, but I just highlighted it because I'm like, the woman. It just sounds very detached, of course. The woman dead, and EMS should be called if they were not already called by the patrol officer 15 minutes earlier, as they would have provided emergency care if the woman showed signs of life. This would have been important for many reasons. Her livelihood is one reason, but from one stance of a patrol officer or criminal investigator, she may have given a dying declaration of her attacker when informed of her impending death. Forensic services are next on the list to call, as they are best equipped to handle the evidence, process it, and ensure that there is not any contamination. Their van also contains the best equipment for forensic investigation. A cursory search of the immediate area should be done, and any observations should be recorded in my field notes as to ensure the integrity of their preliminary case report. Officers who are not needed at the residence should ensure that the general area is searched for anything that stands out as well. This includes the area of the trailer park, which contains 62 trailers. If there's anyone in the trailer, they should be moved out and questioned. Does she have kids? I should gather the following information in my notes as the investigation commences, which will later be included in my preliminary case report when the details of the case culminate. The offense, the time of day, date and approximate time of the offense, if known, identification of the victim, location of the offense, the method of operation, if known, and the identification of the officer. Since the offender was not there, I would be unable to record this information initially, and the specifics of the crime won't be known until confirmed by the crime lab. Getting the approximate time is important and can be indicated by rigor mortis, which sets in at about 12 hours, or putrefaction about 10 to 20 days. All this information will aid me as I attempt to reconstruct the scene of the crime based on the evidence location in relation to its former known position. Like the home that he allegedly chose to target was really the perfect experiment, if I could say it like that, based on just what he knows about crime scenes and just knowing, damn, the risks that maybe the survivors would be drunk, maybe if he planned on having any, I don't know. It just seems to me like he's a very calculated person. I know I'm judging him. I know I'm prejudging him right now. He's innocent or proven guilty. I'm just thinking of him in these shoes and that he's the one accused of those murders. And I'm trying to be like, whoa, imagine. Equipment I will have on hand for the investigation. Now, this is where it gets a little interesting based on what the state accuses him of having. And based on him wearing long black sleeves, black pants, black boots, leaving absolutely no evidence that he was even there from what we know of besides the DNA on the knife sheath, which I wonder, did he intend to leave it there? Was it a mistake? I think it was a mistake, but who knows? Just who knows, right? Maybe he thought all of this would just result in contaminated evidence and that he would just be free. Okay, so to be prepared for the crime scene investigation, I must ensure that I have a crime toolkit containing the following: a 35mm camera or digital camera capable of videotaping with an adequate supply of film and power, a portable lighting system to ensure quality photographs and that I do not miss or step over any evidence, assorted steel tape measures that can reach at least 25 feet, a ruler or other measurement marking devices, latent fingerprinting equipment, gloves to protect the scene from contamination. This will enable that I avoid leaving my latent fingerprints. Okay. As a student pretending to be law enforcement, great. As an alleged killer, wearing gloves apparently, interesting. Allegedly. Forceps and small tweezers and a pair of scissors. A small saw to take evidence, for example, drywall. Filter paper or small swabs for liquid evidence or trace evidence. Various evidence containers for liquid and solid evidence. Paper envelopes for physical evidence. Evidence tape to seal off evidence containers. Casting material to take molds of possible footprints around the perimeter with a rubber container for the mixture. A magnifying device should be kept. Crime scene tape for the scene. Protective clothing. Boot covers, eyewear, fiber-free overalls, face masks, hair nets, gowns, and anything that will prevent me from contaminating the scene with things I bring in with me. Again, pretending to be law enforcement in this essay, cool, A+, buddy. But if you're going to apply this, if you are convicted, if you are the killer, oh my goodness. Because, I mean, he really didn't leave, from what we know, hair, sweat, other DNA, just the knife sheath, right? Lottie said, I would grade him really low for this. It's not up to someone controlling a crime scene to decide what evidence is or isn't admissible just to preserve it. Lottie is saying, you fail. Okay, so a blue light with yellow glasses which makes small trace evidence more visible can be used to ensure a photo is taken of all evidence. There could be a very small amount of blood somewhere which wouldn't have been sampled, documented, or photographed otherwise. Entering the home for crime scene documentation and initial photography or videography. I may enter upon judicial approval of the search warrant and should do so with a minimum number of personnel. Having too many personnel evident in the photography may put the integrity of the evidence into question and taint the scene. A contamination list should be made documenting every person who enters and exits the crime scene and why. This includes first responding officers, firefighters, EMTs, family members, criminal investigators, and all crime scene personnel. Still, There should not be that many people in the crime scene, otherwise contamination will be increased as the theory of exchange inevitably manifests. I really think if he's the one who committed the murders, which is innocent till proven guilty, he's accused, he's innocent right now. He's got to be proven guilty in court if he did it, right? But I think if he did, I'm speculating again, contamination was his main focus. I think he thought that even if they were able to trace that DNA, if he intended to leave the knife sheath there, if it was a mistake, that's another story. I think he was banking on contamination ruling him out or getting him off this, because he's pretty obsessed with contamination. He's apparently diagnosed with obsessive compulsive disorder, and he had said, his parents had said before that he was vegan and he had to have his own separate like cookware so as to avoid contamination of that cookware from animal products, right? So like obviously it goes along with his OCD diagnosis. Contamination-based OCD, it could be like a subdivision of it, and so he's very, very, very focused on that in this, right? So picking a student house with multiple levels, and some are surviving, if he planned it that way, if he did. And I'm majorly speculating. If he fantasized about it, planned it that way, thinking, well, some are surviving, they're drunk, because he would have maybe watched the house for a bit, who knows, and then being like, going in there, some are murdered, some are not, the contamination, the friends coming over, ooh, I don't know. I think he was maybe banking on that, right? Okay, so I must ensure that myself and my fellow crime scene personnel are wearing gloves and other protective equipment as to avoid contaminating the scene with latent fingerprints. A fiber-free boot cover would also be ideal to avoid leaving physical footprints or residue from the boot. That's interesting because he didn't leave, there's no bloody footprints. Like, that's always baffled everyone. How can there not be, except for the one latent footprint outside DM's door, but like where are all the footprints? How did this person do this? Whoever did it, right? He's the one accused. Like, what? So here it says a fiber-free boot cover would be ideal to avoid leaving physical footprints or residue from the boot. Anything that is fiber-free and covers the mouth, hair, and overall body would be helpful in avoiding crime scene contamination, since hair, saliva, skin cells, and other bodily fluid or cells may be added to the scene, thus contaminating it. Fibers can be left via the theory of exchange and would contaminate the crime scene from its initial state as the offender left it. Even if we can't assume that there was an offender, despite seeming obvious, preventing contamination is an important way to ensure the integrity of the investigation and evidence. We should always treat the crime scene as if there is indeed a criminal homicide, as to not miss out on important details. That is how this crime scene is being handled. The first thing for me to do is to take a coordinated series of crime scene photographs with a digital photography device or a 35mm camera from a natural point of view. These photos must be taken prior to the movement of any object in the crime scene to ensure that the photo captures the scene as the offender left it. The photograph should be taken from a general view of the exterior of the home, as well as general views of the interior, recording the time and details of the photograph in my notes. Setting up portable lighting ensures that the elements of the crime are adequately illuminated for photographic documentation. Carla said, I'm OCD. Does that mean you can do what he did too? No, good gravy. No, of course not. Carla, thank you for your sticker. The photo should be in color as to provide the best, most accurate image, thus avoiding photographic distortion. The following details regarding photography should be recorded in the field notes and on the back of photos if possible. Recording these details will ensure that the defense attorney does not attempt to devalue the quality of your evidence, which may make it inadmissible. Data to identify the subject of the photograph, but without too much unnecessary information. The location of the photograph, including the state, city, and street address. The identifying data of the photographer, including the name, police agency, badge number, and identification number. The case number, if established at the time of dispatch. The precise time of the photograph, the date the photograph was taken, the weather at the time. The photographic equipment used, including shutter speeds, film type, and developing and printing techniques. Next, photos of specific rooms should be taken with special attention to the living room in which the deceased woman was found. As the coordination of photos is focused inward, specific components of the crime, like physical evidence, should be accounted for in detail. This should also be logged in my field notes. This physical evidence should be photographed next to a measurement marker, which can be a ruler or any other easily comparable object of well-known size. The body and physical evidence to take a picture prior to collection from the forensic services and criminal investigator of includes the deceased woman in the living room, who should be photographed under adequate lighting from a long view. Specific shots should be focused on the evidence of harm on her body and clothing. One could speculate, if he is the killer, that he could have fantasized about this whole process happening once the murders were committed, but that's pure speculation. The bruises on her face, the marks on her cheek, the bloody shirt, and any other signs of post-mortem lividity should be photographed and taped without moving the victim. A measurement marker should be placed next to her. This will show if an offender moved the woman as to manipulate the crime scene. Does she have defense wounds? Are there hesitation marks on her related to the knife? Or are there multiple stab wounds? These must be photographed and taped. Is the mark on her neck related to the hanger near her? The photographs make sure that these items were indeed present at the crime scene. Most of these questions are speculated until absolutely confirmed by the forensic medical examiner, who can use scientific equations to determine the approximate time of death. This is a maxim that stands even when the scene seems to point to the obvious. The time of death is never entirely accurate, but the photographs can aid in this process as they capture phenomena such as rigor mortis or putrefaction when the woman was found. The knife should be photographed under adequate light, so the woman was stabbed in this scenario of his. Again, if you're only joining now, let's just see, it's about the same amount of people that are here, so I don't know if anyone's just joining now. We are reading Bryan Kohberger's essay, which is 12 pages long. He wrote it when he was at DeSales University, and he wrote it in May, on the May 5th of 2020, okay? So he's saying what he would do, how he would properly process a crime scene if he was law enforcement, if he was a crime scene investigator, basically, right? Okay, the knife should be photographed, as we just read. Okay, so this victim in your scenario was stabbed. Right, and now you're accused of stabbing 4 students. The mishappened coat hanger should be photographed under adequate light, and measurement markers should be placed next to the evidence. The upended furniture and children's furniture should be photographed firstly from a long view and then focus specifically on each piece of furniture under adequate lighting with a measurement marker. All of this should be well documented in the field notes and on the photograph. Is there any sign of forced entry to the home? This would be evident by broken glass from windows and pry marks on the doors or windows surrounding the house. Now, the house that he is accused of choosing to commit a quadruple homicide, that's what he's accused of, he's innocent until proven guilty. There were no signs of forced entry from what we know, because you could just open the sliding door, right? There was that one handprint on that sliding door, which we don't know whose that was. They've never told us, but that's interesting. This should be photographed, videotaped, and documented. If there's not forced entry, it may be suggested that the woman knew her killer. See that? It's interesting. And the front door was wide open. So that's interesting too. Meaning if, again, I'm speculating, if he fantasized about like committing the perfect crime or something, or never being caught, or confusing people, or being exonerated, or whatever it is. Wow. If there's not forced entry, it may be suggested the woman knew her killer. Maybe that's what he wanted. And that's definitely what he got in the beginning of the investigation, because everybody was looking at the ex-boyfriend. Because Kaylee had called the ex-boyfriend like 10 times, okay, right before the murders. And we were all like, what the hell is going on here? So that's interesting, right? So I think he thought contamination is how they're not even going to think of me. And the second reason, and I'm speculating, would be, oh, there's no sign of forced entry. They'll never think it's me. They'll never know. A video camera will be used as well to go over all the evidence which was photographed. Documentation of the video evidence should also be filled out and recorded in the field notes. The crime scene sketch. The crime scene sketch occurs after the scene was initially searched, photographed, and videotaped. The sketch is of great value in criminal court. This sketch should first be done in pencil to ensure that the sketch accurately portrays evidence and measurements pertaining to the crime scene. See, he's also saying pencils first, okay? At least we can relate on one thing there. What? The final version will be done in non-perishable ink via pen. That's what we will use when we know the trial date is for sure happening then. And even then we will have typics. Okay. The physical evidence of the crime scene, which includes but is not limited to the knife, the mishappened coat hanger, Furniture, as well as any other biological evidence like bodily material or fluid, should be drawn out in accurately measured proportions from each other and permanent objects in the crime scene sketch. The final search and confirmation by the forensic processing unit and investigator will determine whether this was all the physical evidence at the scene. New evidence can be added to the crime scene sketch when new measurements are taken. The distance from permanent fixtures should be accurately recorded and depicted. The crime scene sketch should be measured by the criminal investigator and accurately display the proportions of the physical evidence. Any inaccurate portrayal of the location of evidence can influence the juror perception of the guilt or innocence of the suspect. Another thing one could rely on if one turned into a killer with this knowledge. While you do not need to be an artist, the responsibility of sketching should be taken with accuracy and a goal for a clear portrayal in mind. Though I can assign another officer to sketch it, I have decided to take this task on. A 25-foot steel measuring tape should be used to record these exact and accurately recorded measurements of the physical evidence and permanent objects in the house. Too much detail shouldn't be included in the sketch as to avoid confusion. Movable items unrelated to the crime scene convey details irrelevant to the crime and will be avoided. Extraneous detail, including movable furniture, may cause issues if jurors recognize that items in the house were moved after the fact. This would be equivalent to crime scene contamination and may render evidence inadmissible. Still feel like that's what he's relying on. So, wow, I think we've only done like 4 pages out of 12. We're still going. I think I'm going to go just over 2 hours, okay? So please hang in there with me as we go through this because I think it's pretty interesting and important. They're going to show this to the jury. That is what lawyers are saying, at least, right? Lawyers that are commenting on this case, including Josh Ritter from Courtroom Confidential, where you'll be teleported to next for a different video, right? But he was also saying that this would probably, be given as evidence to the jury of, look at all of this, which could, it's an interesting part of the evidence, right? The living room should be sketched out with the deceased woman being drawn in proportion to the knife, the coat hanger, the upended furniture and children's furniture, walls, and permanent objects in the house. Other rooms that are relevant should be included in the sketch. I've decided to use the rectangular coordination method with 2 right angles being outlined in proportion to the physical evidence and permanent fixtures centering around the living room. A projection can be used to document biological or trace evidence like blood stains or other physical evidence that imprinted on the walls. Bullet holes would be something that should be ruled out. And if bullet holes are present, they should be documented on the 3D exploded sketch before the drywall is removed via the saw. Though it appears obvious that the knife was used in this crime, we do not know this for sure and should make sure to document everything and look for less apparent evidence. Even if there was an item introduced to the scene by an offender to throw off investigators, it is not the job of the criminal investigator processing the crime scene to jump to conclusions. We could ask ourselves, did he introduce items to the scene to throw off investigators? He sure studied a lot of serial killers, and that's what they often did, especially the ones that he was studying, right? So, did he? Is that what the knife sheath was for? I don't think so, but is it? Was there any other evidence introduced? Who knows? The crime lab will be able to decipher with scientific certainty what is and is not an original element of the crime. Staging is common. For example, the offender may have taken items from the house to make it look like a burglary turned robbery, which went wrong. Everybody's asked themselves at one point or another, well, from all the coverage I've seen, did he take anything from the house? Any trophies, anything from the house? Did he, meaning the killer? Is he the killer? We don't know. He's innocent or proven guilty. He's just the suspect for now, the defendant in this case, facing the death penalty. Staging is common, as we just read. The official crime preliminary report should include the accurate sketch with the following details included: the name of the investigator and identifying badge number, a detailed location of the scene, such as city, state, street address. The living room should be noted as the center of the sketch. The date and exact time the sketch was first drawn in pencil. The evidence listing or key, which shows evidence as it corresponds to a letter or mark indicated in said key. The case number of the investigation. A compass arrow to give direction. The scale of the sketch should be included, or the words "not drawn to scale." Okay, I'm choosing to draw it to scale, where 1/4 inch equals 1 foot, which I can only imagine, as we would, I'm just speculating, why he would have a problem with the state not having a 3D model to scale. I can only imagine if he is the guy, how much he would be critiquing the investigation, right, from his jail cell. So it says the computer-aided design program, CAD or CAD, which uses laser lights and takes up to 25,000 measurements per second in 3D, may be utilized if available, for the scale of the scene is most accurate, which they used in this case. I would request the CAD if available, for it gives the best portrayal of the serious crime, allowing for an accurate point of view and zooming of particular elements of the crime scene. The more comprehensive crime scene search using the strip search method. In order to collect evidence from the interior of the residence, I will assign roles to officers on the scene, briefing them to watch where they are stepping and not act impulsively or without great care. Hasty actions will lead to valuable evidence being trampled and lost. The strip search method is what I've decided on, as it allows for the interior of the crime scene to be searched from one end to the other with more than one officer or forensic processing unit. The exterior of the property should be searched from one end to the other as well, switching to a grid search if necessary. Walking from one end of the scene to the opposite end of the scene, I will then turn around and cover ground to the right or left without stepping on the same spot twice. The rooms of the trailer should be searched in this method with special attention to the living room, where the victim lies. Assigning a CSI or officer and myself to the section, living room, would allow that the scene is thoroughly checked. As I move from one end to the other, I'll make sure that I shine my flashlight ahead of myself to ensure that I do not damage or carry away smaller pieces of physical evidence. Smaller items of physical evidence include wood chips, hairs, paint flakes, glass fragments, or small fibers. If not careful, these may be lost before even accounting for observing them. If new pieces of physical evidence are uncovered, I will take note of it for documentation and photography or videography. Things such as footprints inside and outside should be prepared to be photographed and videotaped. I must photograph and videotape the new evidence as well as log it with the following information and account for it in the crime scene sketch: the time and date of evidence discovery, the location that I found the evidence, the name of myself or whichever officer, CSI or criminal investigator discovered it. As this is a serious crime, I've chosen that specialized crime scene personnel will assist me. A description of the evidence. Any identifying marks to further detail the evidence. The name of an officer who witnessed the find. I'm like reading fluid. I'm reading ahead. The find. This will ensure that there's no question that this was indeed an element of the original crime scene. This will save the investigator setbacks in court. All the information that is carefully recorded regarding the crime scene evidence aids the crime report. The location of this evidence is very important, for it may give us the following information. More bullet points. I hope that you guys are enjoying me reading this. If you are, and you haven't yet hit the like button, please do so if you like the way that I present documents and true crime. And highlights of all of this. Imagine if we read all the documents that came out, we'd be here for days. Okay, so establishing the tracing of or identification of the suspect. Establishing the suspect's modus operandi or identifying similar MOs via information added to the FBI's Violent Criminal Apprehension Program, VICAP, from the completed crime report. Confirming alibis or exposing lies, disproving the alibi. Ironic. Interesting. Connecting suspects to the crime or eliminating suspects. The identification of contraband, stolen property, and other illegal items. Identifying victims if they are not identified. For example, we can't assume the woman lives at this residence before confirming it. A dead body may not be initially tied to the residence. Interesting. Providing investigative leads. For example, checking into the husband or boyfriend and the location of the children based on the crime scene evidence is warranted. Providing a statutory element of the offense. Now this is 9 on top and it's a 12-page essay, okay? 3 to go. The collection of items of evidence. Like the crime scene photography, larger items of physical evidence are taken first. This includes the disheveled furniture, the children's furniture, cell phone and computer if there, the knife and coat hanger. The body will be taken later by a CSI with a coroner for custody to wait for analysis by a forensic medical examiner trained to perform the autopsy. The knife should be examined for latent fingerprints to be logged separately. Same with the coat hanger, doorknobs around the house, upended furniture, cell phone, and virtually any physical evidence big enough to grab. Crimes of passion are rooted in emotionality and impulsivity. If this is the case, we can likely count on there being latent fingerprints on the doorknob and all over the knife and victim. Okay, so in the crime that he's accused of committing, he's saying then it's not a crime of passion. One shouldn't be tying this document to that. It's just that he was a student of criminology. This is an essay that he wrote May 5th of 2020. And it's interesting just to have some insight into his mind, because he's the accused of a quadruple homicide in a death penalty case. So if anyone thinks that social media is not going to talk about it, holy crap, we're going to talk about it, because like this is a huge deal. Oh my word. So smaller items of biological or trace evidence, such as hair and fibers from clothing, must be collected using metal forceps or tweezers to avoid damaging this delicate evidence, which may hold significant value in the criminal investigation. Fingerprints and footprints are class evidence to be taken with molds or a fingerprinting kit. Fingerprints should be entered into AFIS. I should use a swab where applicable to collect fluids or skin cells which contain DNA. The shirt likely contains not only the blood of the woman, but the blood of the possible offender. DNA from biological evidence should be swabbed, placed in a vial, documented in notes, and on the container for evidence chain of custody, and included to be sent to the crime lab. The shirt will later be bagged and taken separately as physical evidence. I should make sure to swab under her fingernails to see if DNA of the offender is there. She likely dug into their skin. And they did talk about previously Madison Mogen's underneath her fingernail contained a mixture of DNA. 3 individuals, 1 they think is hers and 2 are unknown. It was inconclusive, right? Okay, so it says, is there evidence of sexual assault or semen present? This evidence should be marked, swabbed, and collected in a glass vial or cellophane bag. Is there evidence of personation? Did the offender take something? Or did the offender display an excessive need for control over the victim as demonstrated by a possible sexual assault and murder? These are all observations to be recorded, though not conclusively. During the searching phase, the evidence should be marked with the following information in the field notes and later in the evidence seal or packaging. I am choosing to bag all the evidence and not directly mark it, for it will be sent to the forensics lab. The size of the object, the physical nature of the object, is it a solid or liquid? If the evidence is a liquid, it should always be kept in an airtight container, such as a cellophane bag or a glass vial, and marked. The value of the object and the number of like objects. The case number pertaining to the evidence. Thank you so much, Blair Pernil. Thank you so much. So, the date and exact time retrieved. The initials of the person who marked the evidence. BK in this case, he says. Yeah, that would be him, Bryan Kohberger. This process should be done so as many times as needed. It may occur up to 1,000 or more times. It must be counted accurately, and the quantity should be accurately recorded on the container. Packaging the evidence for the forensic lab. Each item that I collect, including but not limited to the knife, the coat hanger, and bloody clothing on the woman, must be packaged in the proper way for forensic lab analysis. I must use separate containers for evidence, not mixing things up and causing confusion, no matter how daunting this may be. I must use new, clean packaging that was not previously used, as to avoid contamination. Obviously, blood or other biological evidence renders a container spent. Avoiding metal containers, which can be reused, is ideal to confirm the container is indeed disposed of afterward. The package must be sealed with a strong medium, such as strong tape. Items of clothing need to be kept as is and not folded. I must keep evidence that was found in a container as it is and mark it. I must include a letter of transmittal to state what type of analysis must be done. For example, wound analysis, DNA or fingerprinting, even ballistics. Again, I must account for and log all this evidence in the chain of custody form, where it was found, how, when, who's transporting it, and where is the evidence locker located. The woman must be removed by a certified professional and sealed, taken into custody by the coroner. Like the woman. It doesn't ever say the victim or anything like that. The woman must be, maybe this is the language he's supposed to use here. I'm just noticing it for myself, okay? The woman must be removed by a certified professional and sealed, taken into custody by the coroner and sent to the forensic medical examiner for forensic autopsy. This must all be logged in the field notes and initial crime report before compiled in the closing report. The crime scene will be surveyed if necessary, but the longer the time it takes to do so, the more chance the crime scene is contaminated. When mailed, I must always send this evidence in registered mail enclosed with a secure receipt. This careful collection of evidence is all necessary for the crime lab criminalist to be capable of analyzing all elements of the crime, being that they rarely come on the scene. Evidence chain of custody and inventory receipts. The careful description of evidence when, I wonder what he actually got for this. How did they grade this? The careful description of evidence, when and where the evidence was found and who found it are all related to the evidence chain of custody. All evidence must be described and then transported and placed into an evidence locker. The identity of the transporter and the location of the evidence locker must be accounted for. We're almost done. I do want to add that his former professors, that he was studying under said he was absolutely brilliant. Like, he was one of the top in the class. That's why they recommended him for the PhD program at Washington University. So I'm guessing he did pretty well. We do like bullet points, as I say. If the evidence is taken out of the locker at the police department, it must be recorded who did so and why they did so. The knife, mishap and wire coat hanger, and any physical, biological, or trace evidence must be accounted for, bagged and sealed, and then kept in an evidence locker. Her bloody clothing, always distancing language, I understand you're not going to be close to this in the scenario because you're the crime scene investigator, but her bloody clothing should be examined as well. But this would infer that she must be moved and have items of clothing removed. This is something that the forensic crime scene processing unit should do. If she had a cell phone or computer nearby, this should be described, logged, and transported to the digital forensic lab for digital forensic examination. Did she communicate with anyone? Did this communication indicate a conflict? Did her husband or boyfriend contact her? Did anyone else contact her? It's like ironic in the case where he's accused of murdering 4 students. Kaylee and Maddie were in one room. It is alleged that he went upstairs first and killed them first. That is what he's accused of, that their cell phones were there and they were calling her ex-boyfriend like a lot, 10 times, right? So it's interesting that it's like, oh, did you find cell phones there and did they call anyone? I don't know if you would have known that or not, probably not, but it's just interesting now. In hindsight, this may help investigators look in the right direction if things turn out to not be so obvious. Again, we can't assume it was the husband or the boyfriend just because there may have been a history of domestic violence or a PFA, despite this being very common. Also, she may have children's furniture for her nieces or nephews, so we can't assume that she had kids. When moved, all items will have inventory receipts which document the movement for the chain of custody form. All of this is for the accountability and integrity of the evidence and thus the proper outcome of the criminal investigation. Failing to do so leads to injustice. There can be a very clear link between victim and offender, but this is not accounted for via chain of custody, then it will be inadmissible. Outreach to other agencies and immediate elements of the investigation. A lot of these inquiries would occur concurrently with the crime scene investigation. Does she have kids? The county records office should give us this information. If so, the welfare of the children should be ensured. We are aware that there are disheveled items of children's furniture around, but where are the kids? Calls to be made to all family members of the deceased would help narrow down locations. Calls to the clerk of court's office to see if there's a PFA out on the husband or a boyfriend should be made. The husband or boyfriend of the deceased woman should be contacted to establish an alibi. He needs to be immediately located and questioned. The kids should be located as soon as possible and an Amber Alert should be set if they are not accounted for. Does their father even have rights to see the kids under normal circumstances and did he take them? Neighbors should be questioned to see if the father was around or if any suspicious person was present. We're almost done there. Sarcasm says, thank you, G, for always advocating for the victims. I appreciate you, Mods, and the True Grizzly family for helping me and others like me feel safe. Thank you so much, and I'm so glad you feel safe here. So, maybe the father was seen with the kids leaving the scene. This can be important evidence if the father is not responding and the kids are not located, right? So actually, let's go from the top here from page 12. This is the final page. Anyone who normally passes by the scene, such as a mailman, should be questioned and an alibi established. Where were the neighbors when this happened? Their alibi should be evident and supported. Did they notice anything unusual? And we saw those neighbors in the Idaho 4 case interviewed. This is not about that case. This is a scenario that Bryan Kohberger drew up, okay, as a project for his studies. But it is interesting, obviously. Yeah, no, at the 1122 King Road house, yeah, all those neighbors were questioned. They spoke to the media. They became, persons of interest to the public for quite some time. Some still are. Some still email and say, hey, do you remember this neighbor and what he said and all of that? Oh my word. So, okay. Did they notice anything unusual? Maybe the father was seen with the kids leaving the scene. This can be important evidence if the father's not responding and the kids are not located. The Amber Alert can be set based on the vehicle, plate numbers, and description of the father if applicable. Eyewitnesses and surveillance footage in the trailer park surrounding area, drugstore which oversees the trailer, or nearby gas station can give us information on this crime. Yeah, and Elantra was spotted a lot in the crime of November 13th of 2022. Book Mama, welcome, or welcome back, I should say. So then surveillance footage is circumstantial evidence, but may lead investigators in the right direction and to the apprehension of the suspect. Ironic, that's what happened in the case that he was eventually accused of. If we can't gather conclusive information by the end of the investigation, the FBI's Violent Criminal Apprehension Program, VICAP, can help. VICAP can be utilized if this case happens to be unrelated to a domestic dispute. This may be the work of a serial killer, though this is highly unlikely. Still, we are only looking at the facts of the investigation rather than conjecture, and we can only say for sure once the suspect is apprehended and the evidence is strong enough to say what happened with scientific certainty. The compilation of evidence in the preliminary report, progress report, closing report, and prosecution report. My notes enabled that I wrote a thorough and accurate preliminary case report which contained all the facts of the case. I will need to update it with a progress report as we track down suspects and eventually create the closing and prosecution reports which will be used in court if we get evidence of a specific person who committed this specific crime. The closing report will be the culmination of all of the facts after investigation and lab analysis, which lead to the most accurate reconstruction of the scene possible. The steps that I have listed will ensure that the prosecution report and closing report reflect a proper investigative procedure with full admissibility of evidence into the court. All the notifications were made. All the evidence chain of custody and investigative procedure ensured the integrity and accuracy of the evidence of the crime scene. With thorough documentation, it is unlikely that the defense will be able to discredit the investigation and render evidence inadmissible. Okay? This clear information will allow the jury to deliberate based on all the evidence. Finally, adding this information to the FBI's National Incident-Based Report System, NIBRS, will allow the FBI's Uniform Crime Report, UCR, to give summative information of all applicable crimes to help police officers, criminologists, and criminal investigators understand the social trends of crime, thus aiding future cases. Okay, and then here the rest is just all the affidavits and slips and search warrants and all of that, right? So there's nothing that I'd highlighted here. It's also his car records. This is the DoorDash that they had ordered as well. I think that's what that one is. Okay, so there's nothing else I can really show here. We've looked at his driver's license before. YouTube, I'm not showing anything I shouldn't be showing. Anything that should be redacted is redacted. Just looking at the eyebrows, maybe, I don't know. The defense themselves say that he has bushy brows. So that is what we have, ladies and gentlemen. I am sorry that well, I'm not actually. I was going to say I'm sorry that I'm not like looking at your comments the whole time. If I were, it would be annoying because I'd be interrupting the whole time and would never get through all of this. I have one more thing to tell you, which is, remember, I just was going back in time to like, wait a minute, didn't he, because of him describing his demeanor, he doesn't want the jury to judge him, and he's saying it's because of OCD and ASD, but remember when he used to write on a page called Tapa Talk, and he used the name XR, those with visual snow. And he wrote about his experience with visual snow syndrome and his emotional struggles as a teenager. My voice is going, I need water. So yeah, it's almost time to go. My voice has just held up for that. It's going to be like 2 hours 20. Okay, so I just wanted to remind you of something that he posted in there. In a specific post from July of 2011, he titled it, Can You Relate? And he described feeling detached and emotionless, particularly toward his family. He wrote, I feel like an organic sack of meat with no self-worth, reflecting his sense of depersonalization and lack of identity. He further elaborated on this disconnection, stating, as I hug my family, I look into their faces and I see nothing. It's like I'm looking at a video game, but less. These statements convey his perception of himself and others as devoid of emotional depth. likening his interactions to an empty, artificial experience. The posts were made when he was around 16 years old, and they paint a picture of a troubled individual grappling with a rare neurological condition and profound feelings of isolation. So when I had criminal profiler John Kelly on the show here, we had once upon a time speculated maybe, because they speculate, I would think maybe he just really wanted to, a combination of commit the perfect crime and do really well from everything that he studied, but also to feel something based on what he posted as a teenager. That's pure speculation, okay? So I just remembered that today, like, oh my word, remember those posts. And there's so much. We've gone over so much information, oh my word. So if you've never checked out my playlist and you're brand new here, I hope you'll subscribe, notification on, and go check out the playlist, because there's a lot of things that we went over, even in his life. Remember when he was working at like a place where you would have to like cut fish, and he didn't do well with that? I don't know, all of that, and his work history, he overcame drug addiction. He was apparently addicted to or struggling with abuse of heroin, and then he did like martial arts, and then he decided to like start running and apply himself, and he lost a bunch of weight, and he did really well academically. He did really well in his studies. The professors were extremely impressed with him, and then he got recommended, to do his PhD at Washington University. And I just wonder, as he did better and better and better, if he still felt nothing, right? And just thought, I want to feel something. Who knows? He's innocent or proven guilty. He's the accused, he's the defendant. The next court date is April 9th, by the way. April 9th. So we shall see. Everyone, thank you so much. If there's an audio problem, just refresh, okay? Thank you so much, everyone. I will see you in the next one. I'm going to save my voice now and drink some rooibos tea. Like and share. See you soon. Timestamps coming up. Bye, everyone.